Good morning to all. Welcome. We begin our fall session after a long, busy summer here in the city of brotherly love. Glad to be with you all. We have today's not an especially difficult list, but over the 3 days, a long and difficult list, challenging cases. So we look forward to them. Brian, would you like to call the first case?
Commonwealth, Pennsylvania versus Perrin. Bryn is Ms. Marion representing the Attorney's Office is Mr. Michael representing the Attorney General's Office Mr.
Ms. Snyder, it's our protocol that I usually do a very short introduction. So to make, please, you may stand there. Feel free to stand there. But it's just to make sure that we're a hot court, as I think our directions say, and it makes sure that counsel and the court are on the same page so that you don't bother with facts and argue the law, and we can get into it and figure out what's going on and get ready to make a decision. In this case, appellant was convicted of multiple charges with two other defendants in a robbery. At trial, one of his co-defendants testified that appellant was involved, but then that co-defendant later recanted, telling a jailhouse informant, a cellmate, that appellant was not involved. After further proceedings, appellant's case was set for a hearing on his motion for a new trial. Appellant and the Philadelphia DA's office stipulated that the jailhouse informant would testify that the defendant was not involved in the robbery and that the informant's testimony would be credible. While the trial judge accepted that stipulation for its limited view, he indicated that a hearing was still necessary to allow him to judge the informant's credibility and to consider the impact of that on appellant's motion for a new trial. Notably, the Superior Court also returned the case for a hearing. Appellant's counsel refused to call a witness. Trial court found appellant did not meet his burden of proof and dismissed the motion for a new trial. The appellant now appeals, arguing that the trial court abused its discretion, or I suppose committed an error of law, in requiring a hearing and dismissing the motion for a new trial when counsel refused to participate. So if that's about it, go ahead and tell us why the trial court made a mistake.
May it please this honorable court, my name is Marion Snyder, and I have had the pleasure of representing Dantes Perrin since September 15th of 2016. The 6 years of worry and work that I've put into thoughtfully and zealously representing my client leads me to feel exasperated at being back in the appellate courts again after finally having convinced the district attorney that we had been right all along, that my client should get a new and a fair trial. As far as being on the same page with the court, I take issue only with a few things in the summary of the facts that the Chief Justice just gave. I don't consider what Linwood Perry said a recantation because he never expected his conversation with Curtis Brown to come to light. It was spontaneous. That gives it more credibility.
Although if he had testified and said that, it would have given the trial judge an opportunity to assess that.
Correct. I did not expect Mr. Linwood Perry, who I believe is not really a rehabilitated person who had been truthful in the first matter, to come to court in the trial court and say that he had lied to us. In fact, I expected that if he did, in fact, have the courage to get onto the video screen, he probably would have said that he did nothing of the sort. He probably would have screamed about his federal sentence being higher than he thought it was going to be, and I still would have had to put Mr. Curtis Brown up in order to rebut that. Also, the stipulation that was entered was significant in that it covered many things, not just that Mr. Brown would have come in and said that Mr. Linwood Perry had revealed that he had lied about Dantes Perrin. Instead, Mr. Curtis Brown would have come in to repeat consistently the statements that he gave in 2011, 2009, 2017, and the testimony that he gave under oath when subject to cross-examined by the district attorney's office, who had qualms and doubts having not talked to him in person and investigated the case carefully.
Counsel, did you ever give a reason in front of Judge Campbell that, because I didn't see it, as to as to why you couldn't call witnesses at that hearing?
I did not, and I also wouldn't have used the words couldn't have called.
Well, you did decline, right?
I declined, yes.
And how are we to find that the trial court abused its discretion in this case when the higher court, the Superior Court, had told it had to conduct a live hearing and that a cold record was not adequate? How can that be an abuse of discretion?
Because when the Superior Court had given that remand instruction to the PCRA court or the trial court level, they had given that under the understanding that this was a disputed hearing where we would continuously talk about how the district attorney believed that Mr. Brown was lying, that the district attorney didn't have enough information to determine that Mr. Brown was telling the truth. And honestly, at that point, they were fighting hard about the fact that Mr. Brown was lying, not really noticing that in their own transcript from that evidentiary hearing in 2017, their proposed impeachment fell flat.
So just one brief follow-up question. Because I'm not asking about cases globally or universal cases, but about this case.
Yes.
Here, the relevant part of the Superior Court's opinion said, so that the trial court need not rely on a cold record to make its credibility determinations. Here, you're telling me that you and the DA's office had made a joint credibility determination, and instead of the trial court making one, that you two were allowed to make it for the trial court, and that the trial court would abuse its discretion and said, if it had said as it did, you know what, thanks folks, but I'm going to make my own credibility determination. So in this case, how can that be an abuse of discretion?
Well, yes and no, Your Honor, because I do dispute some of those facts. At the time that the Superior Court made the remand, there was still that dispute. At that point, I really read that edict from the Superior Court as saying there is an issue. Here is how to resolve that where there is an issue. By the time we came back in front of the PCRA court, there had been an ordering of the notes. There had been an investigation independent for each party, because I did not participate in the DA's office investigation despite some of the claims that amicus counsel has made, as to what they were now willing to stipulate to. The facts that were stipulated to were the facts that would have come out at another hearing and the facts that had come out of the next.
Counsel, permit
Yes.
me. I want to follow up on Justice Sweck's question. The issue here is did Judge Campbell, are we going to find whether he abused his discretion? Yet he followed our decision of Mater versus Duquesne made 2 years ago that litigants can resolve certain issues, but not business of the court. Therefore, he observed the order of Superior Court, which directed a full and fledged hearing. Tell me how he abused his discretion by obeying our rule.
I think it is the blanket refusal that was an abuse of discretion to consider the documents that had been stipulated to and that were in front of him. There is no...
Excuse me. The exact language that this court, all 7 of us that you're asking us to find that Campbell abused his discretion, said, litigants, you can resolve certain issues, but not business of the court. Are you now sharing with us that the order of the Superior Court remanding for a full and fair hearing is not business of the court, and that you and your partner, the district attorney's office, have a right to supersede the order of the Superior Court? Is that what you're sharing with us?
No, Your Honor, I don't believe so. I read the Superior Court's order to be to resolve the issue in a just way. And
Wait, excuse me. When a just way, did it say just way or did it say remand for a full hearing? It's a very specific question.
I don't know. Your Honor, I guess I had considered that the Superior Court saying that the record can't be cold, that a credibility determination needs to be made, was the actual command, rather than the full hearing part.
Was the word a full hearing in the language of the remand?
Yes, but they went...
Okay.
Oh, I'm sorry, Judge. They did go on to say that the purpose of such a hearing would be to make a credibility determination.
Ms. Snyder, it doesn't appear that it goes well for you here, and I'm with my colleagues. being really candid, this smells bad. I mean, it looks, and I'm not accusing anybody of anything, but it has an appearance of skullduggery. It has an appearance that a DA who is, and I mean this with greatest respect, but is somewhat notoriously friendly to defendants, and defense counsel wanted to keep this case away from the trial judge. And, you know, and I was a trial judge for 13 years, Judge Doherty, Judge Weck were trial court judges. We're not potted plants. We're there to make sure justice is done. The judge said to you, I need to hear the case. You're not seriously arguing to this court that the judge doesn't have the authority to do that.
Not exactly, Judge. What I'm saying is that it should be the ability of the parties to stipulate in order to keep letting the court do its business, its actual business in making those decisions. And that's why we're allowed to stipulate to certain facts and but not certain conclusions.
Then why didn't you go forward with a hearing with that stipulation on your record, and then we could be here with a very different scenario than we have now?
Yes.
Counsel, in follow-up to the Chief Justice's point, even if everyone is acting with the utmost good faith and there is no skullduggery and people are just trying to do exactly what the rules prescribe and what the Superior Court directed them to do, can you at least acknowledge that there is a big difference between a stipulation of facts and a stipulation that encompasses credibility determinations? And I think that's what we're struggling with here, because if the trial judge was presented with a stipulation of facts, the incident occurred on the corner of 6th Avenue and 9th Street, you know, we all can agree, okay, the judge can accept that without any problem. No evidentiary hearing needs to take place. It's a stipulation of facts. But when the stipulation encompasses credibility determinations and who said what and what actually happened, what scenario took place, who is to be believed over someone else, I don't understand how we can ever say that stipulation, while accepted by the trial judge for his consideration, has to be accepted as fact. And that's where I'm hung up on this, accepting the stipulation, and why the judge was not free to do as the Superior Court directed, conduct a full evidentiary hearing.
I now have 5 questions in front of me, so I'm going to do my
Although
best.
I thought that, but I think they all have a central theme. So we'll be quiet for a
agree.
second and let you answer.
Thank you. I do believe that the abuse of discretion here was not even considering the stipulations in the joint memorandum, because had they been considered, it would have been clear that they were appropriate, that they were actually almost as simple as a factual stipulation. We were just noting the facts and how often they had been testified to in order to explain we both think they're credible. So if you break it down, really what we were saying is, this is what Curtis Brown would say. And now he's said it this many times, and we're not going to ignore that in our stipulation and just say this is what he was going to say. We're going to say this is what he said in 2011, this is what he said then, this is what he said under oath. This is what he said under oath subject to cross-examination at a full hearing, where I actually said on the record sometimes when something was objected to by opposing counsel, Your Honor, I need to put enough on the record for credibility determinations to be made. So what we stipulated to are the facts, and that he said it over and over and over again, and that he has met with the district attorney's staff without me, without other counsel, and that they found him to be credible, If I litigate a motion to suppress, for instance, in court, and I lose, and I want to preserve my client's appeal rights, I stipulate to the admission of the record from the motion to suppress, minus any inadmissible evidence, and we both rest. Unless I've actually alerted the district attorney to some sort of sufficiency argument that I plan to present, the judge just says guilty, and we move on to sentencing and appeal. The defense uses stipulations in criminal law all of the time, and the parties have to be transparent with one another. And then, as we are there transparent with the court, that's why there's no funny business going on. And there were...
But counsel, we don't allow experts to speak to the ultimate issue of the case. But you're asking us to accept the ultimate issue, that being believable or not, the credibility of a witness, to be determined by the district attorney's office and the public defenders. Share with me how that's congruent.
I'm not at the public defender's office, just for clarity, but I am
defense
appointed in
attorney.
this matter. And it's because the parties bargained for that, investigated it, were transparent with our investigation, had someone on the record under oath multiple times, and also because 10 years later, putting on a hearing would have, I would think, less of an effect on the fact finder.
Where did Campbell abuse his discretion by requiring a hearing so he, as the trier of fact, could make a determination as to credibility? Share with me. What did he do? Was it when he said, no, I'm not allowing you to stipulate, I want to hear that which I was duly elected to do? Is that what his abuse of discretion was, doing his job?
I
That's
of
a real
course want the judge to do his job, but I do think that by not considering those stipulated two facts, that was an abuse
But
of
counsel, and again, I'm following up on Justice Doherty, and maybe we're beating a dead horse here. Two things. First of all, it was not Brown's credibility that the trial judge had to ultimately determine. It was Mr. Perrin's, who had come in to testify. I'm sorry, not Mr. Perrin, Mr. Perry. Mr. Perry, who had come into court and testified against Mr. Perrin, right?
I'm sorry, say it again. At
The
trial,
co-defendant was Perry.
yes, at trial, it was Mr. Perry's testimony.
Right.
that-
So ultimately, we have to decide if Perry was lying in the courtroom when he implicated Perrin.
No, I don't believe, so I believe that the PCRA judge has to decide whether Mr. Brown is credible in the story that he heard Mr. Perry say that he lied on Mr. Perrin, and that if the fact finder had heard that evidence from Mr. Brown at the original trial, he would then have significant doubts, and the result would have been different
But
as to
don't
what
you
Mr.
see,
Perry...
and if you don't see it, that's fine, and we'll move on. Don't you see that your answer, that if the trial judge had accepted the stipulation that Brown was credible and Brown heard it from Perry, that doesn't answer the ultimate question, which was whether or not Perry was whether Perry was lying when he spoke in the courtroom or lying when he spoke to Brown. And the trial judge has to see something more than Brown saying, well, I'm convinced I'm credible. Brown might be credible. That doesn't mean that Perry was not lying when he spoke to him.
But-
Brown can still be credible, but Perry's the one that has to be credible or not credible.
Right, but I guess I'm confused because Mr. Perry was not coming to this hearing either way. So if you're saying that we can deduce from the record that Mr. Brown is credible, then why would I recall Mr. Brown when I've been offered a well-investigated
Let me ask you
regulation?
one. Did you finish that answer? Did I step on? Okay. I wanted to ask you one more question, and then I'm done. I promise. You didn't say, if my notes are correct, you didn't say that, well, this case can be resolved on what we have. You said it would be against my clients, and your client is Perry. It would be against my client's best interest to call a witness here. I don't know what that means.
So
I guess I don't think it does, but in a pragmatic sense, it raises an adverse inference that if you put Brown on the witness stand, things aren't going to go well for you.
that is not at all what I meant. As an experienced lawyer, I would much rather rely on a stipulation like this one, which is well investigated by each party independently, containing facts fleshed out during a full-day evidentiary hearing with the witnesses under oath and subject to cross-examination and transparent in its reasoning and request, than to call a citizen to the stand almost a decade later to recount a short conversation with Linwood Perry and a short conversation with Agent Majarowitz, and authenticate and adopt two more written statements that were practically reproduced in the stipulation already. This court acknowledges the gauntlet that litigation can be, especially unnecessary litigation. Despite the hassle for Curtis Brown, Dantes Perrin, the backlogged First Judicial District, and yours truly, it really shouldn't be a necessary step for Dantes Perrin, whose freedom has been impeded by wrongful conviction for all these years. He shouldn't have had the conviction on August 25th of 2017, and it shouldn't stay with him any longer. My frustration is that we are in fact back in court,
Counsel,
in the appellate courts now.
Can I go in a different direction real quickly? First of all, this is the first time in my years as a judge where I've heard skullduggery in open court, so that's exciting for me. I might try to use it some other time.
Because of your career on Commonwealth Court, there was no skullduggery.
There was no skullduggery in Commonwealth Court, no. Maybe there was. So I just have a quick factual clarification question. You mentioned PCRA. This was a direct appeal, right? We're not in PCRA.
Yes, I'm sorry.
Okay.
We are in direct appeal. I think I got thrown off because we have been talking about after discovered evidence for so many years, and in fact, that was before I was even involved.
Because this was a bench trial, criminal bench trial conviction,
Yes.
where the witnesses were resolved in favor of the Commonwealth and a conviction occurred.
Yes, there are some important things to note, though, as your honors are making the decision about that. The trial court judge did note that he had qualms about the identity.
I'm aware of the alleged
Other
reported
than that-
weaknesses of the prosecution's case. I get that. My question is, let's say things aren't going well for you here, and let's say at the end of the day, this court might conclude that there was no abuse of discretion by the trial court judge here on remand from the Superior Court. I am taken a little bit by your passion and your concern for your client. And despite the fact that you were given numerous opportunities, I'm assuming you were trial counsel as well?
Oh, no, that's what I mean. I actually
whoever the
wasn't even direct appeal counsel.
Okay, whoever the counsel is that's handling the actual proceeding in front of the trial was given numerous opportunities, I think maybe 3 opportunities to present testimony on remand and refused. I'm still sensitive to your passion for your client, insisting that your client is nonetheless innocent and wrongly convicted. If we send it back again for a 4th time, will trial counsel for the defendant go forward and comply with the directions of the trial court judge and the Superior Court on remand?
Yes, so that was me. I'm sorry. I then confused where Your Honor was going with the procedural history. And yes, I'll track down Curtis Brown. Of all the Curtis Browns in the city, I did last time with an investigator, and I will beg him that even though he's put this behind him and it's been all these years, please come to court and testify truthfully. I just, as an attorney, putting a witness on the stand multiple times, a witness who has indicated to me that he is sick of coming, a witness who in the record did not make it that day. I had to call the witnesses out of order because he still didn't want to have to come back to court. He has had people in the neighborhood talk to him about PIs being around. I'll do all of that. And I could have done it before, except I was offered a really smart stipulation for my client to accept because of all the work that I had put in for years while they were fighting me. And then when I finally convinced them that I was right, that Curtis Bryn was telling the truth, that Dantes Perrin is innocent, I finally get my day where we all agree, and I'm back here. So I will do anything for Dantes Perrin.
Could I follow up there? But then you were given the Superior Court gave you your day, and when the court called for Brown's testimony, and you had found him or sponsored him or whatever, you declined to present him and said it was against your client's best interest. And how is it that you can convince us that the court has to be bound by that? That the court can't say, that's strange. I think I'm going to hear the testimony the Superior Court told me to hear and make my own decision. How can that be an abuse of discretion?
Because it was already because of the nature of the stipulations, because I thought that the law said that I could, and I thought it was the right way to go.
It seems a lot like, just one brief follow-up there, when you say that, it seems to sound a lot like the Brown case, albeit in a different context, on the confession of error case, because it seems like, just like that case, you in the DA's office want to tell the courts how to conduct their business. And it seems a lot maybe to follow up on the chief's insight. I think it's like it seems to look a lot like the tail wagging the dog. And there does come a time, it seems to me, when the court gets to make its judgment, particularly whereas here it was told by the Superior Court to make its credibility determination, given that it was a new trial judge.
So, Ms. Snyder, what we're going to do is answer Justice Weck's question, and then Justice Donoghue has a final question for you, and we're going to move on.
Yes,
so
Your
go
Honor.
ahead.
I think that this case is a little bit different, the analogy of the tail wagging the dog, because in this case there were ample fact-finding missions all over between the FBI, the written statements that were entered into evidence, the testimony. And so that is why I honestly did not realize did not think that we were taking business from the court, but making things easier for the court, is because this was a robust record where we were finally agreeing. I finally got through to someone. That's really why. That this had such a record. We already had all these things down. You could read the stipulations in this matter that were not one page long and say, wow, they really flushed this out. They're not hiding the ball. Look at all this stuff in front of me in this 8-page stipulation, and it's the last paragraph that says, and then therefore credible or therefore deserves relief. I just got through to them after 10 years, and I just think that record was where we needed it to be to show that Mr. Perrin was not guilty.
Well answered,
Well,
Justice Donoghue.
you didn't get through to the trial court. so
Understood.
Lesson learned here, it doesn't matter if you get through to the DA, so for future times. But my question is a little bit different because I thought we took this case for a much broader decision as opposed to essentially error correction here. Do you foresee a stipulation as to credibility that you would say a trial judge doesn't have to accept that? I mean, is there a case where a trial judge can say, I'm not going to do that? I mean, you've gone over in great length what you had here, which was the witness said the same thing multiple times. That's about it. Okay. Is there a case where, as you see it, it would not be an abuse of discretion for the trial judge not to accept a credibility stipulation?
If the parties I have had happen to me entering into a stipulation with counsel where I thought that we were on the same page, that stipulating 2 facts also meant stipulating that those facts are true and those facts are there.
But facts are verifiable, and
Right.
that's what I have a sort of a hang up about all of this, and Justice Todd touched on this. What you're arguing is that the trial judge had to accept a stipulation as to an opinion that was drawn by both sides of this case. Okay, but credibility is nothing more than an opinion essentially based on a non-verifiable fact. Is the witness believable? And from my perspective, I don't see any situation where a trial judge would ever be bound by a stipulation as to credibility.
I hope I'm understanding your question correctly. I think that there is a place where you may stipulate to an unverifiable fact. That's okay with Your Honor in this hypothetical.
I don't know that. I mean, I'm looking at, there are often times when parties will stipulate that a expert will testify as to X, Y, and Z. That's an opinion. But the reason that that's acceptable is because that opinion is based on verifiable facts that each side could get their arms around. That's not what you have with credibility. I mean, what we're hearing here is an argument that 3 assistant district attorneys, 1 defense counsel, equals a judge's opinion on the credibility of a witness. And that's the aspect of this. I mean, you know, what you're arguing is almost as a matter of law, what you had here had to be accepted. And I just, I cannot put this stipulation as to credibility into any silo of stipulations that I've ever seen as a judge or, frankly, as a trial lawyer.
I think what comes to mind is, what about a stipulation to a interview taken by a detective that is line for line but not recorded by audio or visual, and two parties stipulate that that's what the witness would come in here and say today, and it's completely undisputed. I don't expect the district attorney at the end of the trial to get up and say that everything in that interview was a lie if we've both stipulated to it. Now, I have been burned on that, appealed, fixed it, all of these things. So I now ask that it be put in, or that we speak about whether or not there would be some sort of surprise, and I wouldn't do that to other counsel.
There's nothing wrong with what you just said. Here's what he's going to testify to, period. Right. What's missing from your example is the following: and this witness is credible. This witness must be believed. Well, that's the part that is sort of the tag on to this scenario that I just don't see fitting into any established set of circumstances in which a stipulation would be acceptable to a court.
When we instruct a jury, don't we in fact say that this should be considered by you, that this should be taken into account, that that's undisputed?
Decide whether it's credible.
Yes, but they don't have anything to base that on other than said stipulation. So it's possible to take a credibility determination and to make a credibility determination without seeing someone's face.
Satisfied? I'm done. Thank you very much. Well argued. Mr. Gormisa, you're going to go next? Okay. We're pretty, I mean, we try to give full arguments. We don't have time limits. I think we've argued this pretty fully for the defense. My understanding is your position's identical. So I'd appreciate your limiting yourself to what's not been said, which, again, it seems as if what's been said is pretty comprehensive.
Well, I would hope the DA's office has something to say that's not identical to the defense.
Thank you, and I will try not to repeat
Thank you.
what Ms. Snyder said. Good morning, Your Honor. My name is Michael Darmis, and I represent the Commonwealth in this case. The heart of this case is really that the post-sentence court, because this was a post-sentence motion, didn't think it had the authority to accept the stipulation because they were a stipulation to credibility. The post-sentence court found and applied a per se prohibition on stipulations to credibility. And it seems undisputed that credibility stipulations in some very limited circumstances are appropriate. So the post-sentence per se rule and blanket prohibition on accepting a stipulation to credibility was an error of law that constitutes an abuse of discretion. There's 2 points in the record that make it really clear that the judge below was exercising a per se blanket prohibition. You can find it in the order in which the court writes, quote, "The court concluded that the determination of credibility was not amenable to stipulation." And at the actual hearing on August 6th, when we were before the court, Ms. Snyder was marking the stipulations into evidence. She was saying that the court now can apply the applicable after discovered evidence standard to those stipulations, at which point the trial court interrupted and said, haven't I already, basically interrupted to disagree that he had already found he could not apply the law to a stipulation because he was applying a credibility stipulation, because he was applying a per se blanket prohibition.
Wasn't he actually, though, applying or trying to follow the Superior Court's directive that he hold a full evidentiary hearing?
So the remand order from the Superior Court, and it's important to remember it's a remand order. This is in the same posture as a post-sentence motion that should have been decided within 120 days of the sentence. But in that posture, the remand order authorized a hearing, essentially a duplicate hearing, and I would say the
Did it
operative.
authorize it or did it direct it? What's
So
the
I would say the operative language is it need not rely on the cold record, but it was still authorized to have a hearing where any admissible evidence could have been offered, including this stipulation.
But counsel, you just shared with us that the court, in essence what you're saying, the court abused its discretion as an error of law by saying it refused the stipulation of credibility. It then ordered a further proceeding so that there be no cold record. Are you sharing with us that the court didn't direct counsel to put forth evidence at the remand such that the witness would have to testify, which would have been supported by the record when counsel on the record said they chose not to call a witness? Now, how does that fly with your argument? Because that's causing me to pause.
So I would say it's a little bit complicated procedurally because there were a number of listings. The only evidentiary hearing was really that last one on the video screen in August. The prior hearings were status hearings where legal arguments were being presented that this stipulation could be accepted by the trial court.
But the court did not. It chose not to, which is within its purview as the trier of fact. So share with me how that's an abuse or an error of law.
Because instead of exercising discretion, the lower court applied a per se prohibition, a blanket rule refusing to accept this kind of stipulation, and that was an error.
And share with me how that violates our decision 2 years ago in Mater versus Duquesne, in which we specifically said business of the court cannot be stipulated to by the trier of fact. That meaning the trial judge obeyed the order of Superior Court to proceed with quote-unquote a proceeding. Now, how is that an abuse of discretion? Because he chose not to accept your stipulation.
Because he didn't apply discretion with regard to the 24 stipulations that were at issue here, including the stipulation that a FBI agent who had previously testified would testify the same way he did at the prior contested hearing, and the FBI agent would do so credibly.
But counsel, to follow up on Justice Dougherty's question, this aspect, though, related to the language of the Superior Court's remand, it says, we remand for the determination of whether Brown's testimony was credible, etc. We direct the jurist appointed to handle this matter, it's a new judge, to hold a hearing at which Perrin shall present his witnesses again, so that the trial court need not rely on a cold record to make its credibility determination. So far from making a blanket statement, it seems here like the new trial judge was simply trying to comply with the Superior Court's specific language with respect to a credibility determination regarding Brown. Now, granting for the moment, for the sake of argument, that it would have been within the judge's discretion to say, okay, I accept your stipulation on credibility, how can it be an abuse of discretion for him to go the other way and say, I'm going to hear this testimony? Couldn't he have done it? Didn't he have discretion at least to do it the way he wanted to do it, assuming he had the discretion to go the way that you and defense counsel wanted?
So that's not what happened in the court below. Had that happened, we would not be here, because had the court not applied a blanket per se rule, there wouldn't have been an error of law to appeal.
I figured that's where you're going. I don't understand that rationale. If we say you're right, and, he committed an error of law, it was a blanket per se rule that he applied, and it goes back and he goes, okay, I was wrong on the blanket per se rule, but I'm now exercising my discretion, and I'm not going to accept your stipulation, you're no better off than you were before.
Well, I think at that point, witnesses could be called, and I think that at that point, some of the witnesses might not need to be called, such as the FBI agent who testified under oath about this incident was cross-examined.
No, but either way, the trial court judge got to do what the trial court judge did here. That's what I'm saying. If your objection is just though the trial court judge just announced this blanket black letter rule of law that he is not going to ever consider a credibility stipulation. I mean, maybe he did, maybe he didn't, but I'm sure as hell convinced if we send it back on that error, alleged error, the trial judge would say, okay, maybe there's no blanket rule, but I'm still not going to accept the credibility stipulation.
So if that happened, then the defense would properly be in a position to call witnesses.
Right. So this is what we're arguing over? This is why we're all here? The result would be the same.
Yeah. May I ask you, I think Justice Donahue made a wonderful point at the closing of prior counsel's argument. As I alluded to when Ms. Snyder testified, I'd like to think that our trial court judges, some of us included in prior days, are not functionaries, are not our system is designed so they cannot be reduced to having no input in it. So the trial judge, and I can't get into this trial judge's mind, but the trial judge is disquieted by what's occurring, is not convinced that either justice or law is occurring, and wants to explore it further. And it seems to me your position is the trial judge doesn't have that power. And again, I am not ascribing improper motive. I'm exploring a legal issue. But that the district attorney and the defense counsel can preordain a result and cut the trial judge out. Is that your position?
It's not, but the court can't exercise a per se rule that prohibits a category of admissible evidence. And if I could just respond that I think, perhaps the court is getting to the argument about Brown, and I can understand why this might look like Brown, but this is different for a couple reasons. This case has an unusual posture where the legal issues were decided essentially as preliminary objections before we got to court, and they were vigorously disputed by my office, and the courts ruled against us. And so to the extent there is, so those were the court's decisions, not the Commonwealth's decisions. And so while it may look like it is outcome determinative, it's only because the legal issues were previously litigated and lost.
But one more time, last time I'll ask, and again, I'm trying to parrot Justice Donahue, so if I'm doing a bad job, she'll take over for me. I think her suggestion was, and what I'm interested in your comment is, the trial judge is, I'll use the same word, disquieted by what's occurring, and said, I won't accept it, put your witness on, I want to see and hear them. I think what Justice Donahue was, and maybe persuaded me, is the trial judge has an absolute right to do that, and counsel is at the jeopardy that she finds herself here if she says, I will not, which means she doesn't carry her burden and she loses. Trial judge, fine, you will not. Next case. This one's dismissed. Does the trial court, I'm going to quit digressing, have the absolute right to say, I want to hear witnesses?
The trial court does, but that's not what happened in this case.
I understand your position. Okay. That's a fair answer.
Counsel, I'm not sure you and I are on the same ultimate conclusion, but I think we're somewhat on the same page. You're actually arguing this was an error of law because there was a per se rule, and an error of law can be an abuse of discretion, okay, for reasons that have always been unclear to me. But this trial judge, the best he could have done was accepted the fact that the district attorney's office and defense counsel agreed that the witness was credible. That doesn't mean that the trial judge then is bound by your credibility determination. Because credibility, and this gets down to this question, I thought, which was really sort of the broader issue that we were looking at, which is whether or not credibility is ever the appropriate subject matter of a stipulation. Because at the end of the day, your agreement that he's credible has nothing to do with the trial judge's judgment call on that same issue. It's unlike a factual stipulation where there's nowhere else to go with it. There's nothing else I could do with the facts that have been stipulated to. When you're talking about a witness's testimony, it's the quintessential judicial or any fact finder function in that context to make the credibility determination. So contrary to what I think you're arguing, my position, and believe me, I'm not, this is not on, firm ground here, but I would sort of right now come down on the side of you can never stipulate to credibility and bind the trial judge with that stipulation.
So if I could answer in a couple ways. First, anytime there is a disputed fact at a trial that's being resolved with a stipulation, once the stipulation occurs, it has been proven. And so you get a jury instruction at a jury trial basically to that effect. Ultimately, credibility is a bundle of smaller facts, and so each one of them individually can be stipulated to and ultimately concluded. So it is lack of bias, consistency, opportunity to observe, and so all those other factors that were part of the stipulation and that importantly in this case were flushed out in a contested, fully cross-examined evidentiary hearing in 2017. So I think that that is where that difference is, and when I understood the amicus brief discussing that there are limited situations where such a stipulation would be appropriate, it's basically because if you don't have a stipulation to credibility, you are losing the functional effect of a stipulation, even if it is an expert witness. If you're all of a sudden going to be arguing that they're not credible for other reasons such as bias, they were paid as a hired gun, something to that effect.
Okay, thank you.
Thank you very much. Mr. Eisenberg?
May it please the court. To the district attorney's argument, I would point the court to the, I'm sorry, Your Honor, Ronald Eisenberg for the amicus attorney general's office.
Could you pull the microphone down a little bit? Thank you. So we could, yeah, so it's by your mouth. Thanks.
It's unusual, Mr. Eisenberg. It's unusual for the Attorney General to be arguing a case in which we have the District Attorney's Office arguing, but in this case, since the District Attorney's Office of Philadelphia was taking the same position that the defense attorney was taking, we made took the unusual step of allowing the Attorney General to also represent the Commonwealth to get the opposing viewpoint of the Commonwealth.
Thank you, Your Honor.
And Mr. Eisenberg, you've sat and obviously listened. We've explored at great length. If you can focus on where you can elucidate something, that would be helpful.
Yes, Your Honor. The trial judge had actually not 3 but 4 listings at which he gave the parties the opportunity to present evidence. They were all very short. I urged the court to review them. In 2020, on February 13th, March 12th, July 9th, August 6th, and he made similar brief comments at each one. Here's just one of those brief comments at the very first listing. I received the proposed stipulation from the parties. It's this court's position that accepting that stipulation is contrary to the Superior Court's directive and also sets a very bad precedent for this court to relegate its duties to counsel. And on July 9th, the third of the listings, he said, the fact that the parties agree doesn't satisfy the purpose of the remand. I received and reviewed carefully the joint memorandum. While it's well written, it is largely unresponsive to the court's concern with proceeding via stipulation. In other words, we know the case was remanded. We know what a stipulation is. We know that the parties agree. This was clear even before the briefing. So whether the defendant's entitled to relief is for the court to determine, not for the parties to decide simply because they're in agreement. Accordingly, we scheduled a hearing. So the point of this, Your Honor, is that in fact the court was not applying some kind of per se rule of admissibility, and perhaps that's why neither party argued to the court that he had erred in that way. Neither party argued to him, the judge, you're abusing your discretion because you are committing an error of law. Instead, both parties simply said over and over after the judge had ruled against them that the judge was obligated to accept the parties' stipulations because of the fact that they had stipulated. So the bottom line here is that the only people in this case who are taking an all or nothing approach were the parties. The judge wasn't, and we as the amicus are not. there may well be circumstances where parties properly offer stipulations. There may well be circumstances where judges exercise their discretion not to hold a hearing. The question here is whether they are ever allowed to exercise that sort of discretion. The position of the parties below was that they are not. That's why this court becomes like Commonwealth versus Brown, because it's, again, an all-or-nothing position that was offered to the judge, where he either accept what the parties offered to him or they weren't going to go forward.
Counsel, what is your office's position as to stipulations regarding credibility?
Your Honor, that's a large question which I think doesn't have to be answered in this case, and I understand Justice Donahue's views, which I...
IG. If what we're here to do is error correction of the trial court, I don't know why we would have this case.
Your Honor, I'm not saying that nothing should be said about it. I'm saying that the context of this case is a post-verdict after discovered evidence claim is what's dispositive on that issue of stipulations to credibility. Whatever might be the rule at other times, certainly after a verdict has been entered and there is a claim of after discovered evidence, certainly at that point the judge must be empowered to exercise his ability or her ability to consider the evidence and make their own credibility determination.
Should we limit our ruling, going to these points, in your view, should we limit our ruling to a circumstance like this where the Superior Court specifically directed a credibility determination and a live witness?
I think that the Superior Court's directive is certainly a significant factor, Your Honor. I don't think it's essential. I think actually your own comments in one of the earlier appeals in this case are more apt, which is that when it comes to an after-discovered evidence claim, we're really relying on the trial court's ability to assess credibility, and the trial court needs to have that opportunity. So it's not just that the Superior Court directly ordered it, and it said, we direct. It didn't say we suggest. You can do it if you'd like. It said we direct. But it's also the fact that this is an after-discovered evidence claim where the effort is to vacate a judgment of sentence. And in Brown, as this court pointed out, the discretion of the parties and the discretion of the prosecutor varies over the life of the case.
The problem, I'm not sure that the procedural posture should control the question you're addressing. The reason that the DA here has to go forward is that he no longer has the charging discretion to withdraw charges and say, we choose not to prosecute. And that's the importance of it, it seems to me, of it being on post-trial motions. But the legal principle that the trial judge can demand to hear from witnesses and can assess credibility would seem to me to be equally applicable to a trial situation if the district attorney, and it's not Philadelphia, the district attorney in Pennsylvania chooses to go forward with the charges.
Your Honor, I'm not saying that the court couldn't issue a broader ruling, but I'm merely saying that in the context of this case, I don't think that's necessary, and yet it would be much more than mere error correction of this particular case to make a ruling appropriate to the post-verdict stage.
If I could, I don't think, though, that you're disagreeing with the prospect, Mr. Eisenberg, that this case, while factually perhaps unusual and while involving a Superior Court directive, does tee up the ultimate issues that we've been speaking of what does a stipulation that includes credibility determination mean to a trial judge, and can that trial judge then, is that trial judge bound in some way? Does it in some way limit his duty as a trial judge, or what he can go on to do that he regards as his responsibility, as his role as a trial judge? Because those are really the two broader questions that we're interested in, not the specific limiting facts or procedures of this case.
Certainly, Your Honor, and I'm certainly not arguing that only...
And they are interesting issues.
They are certainly interesting issues, Your Honor, but it is also true that there may well be a difference between a stipulation to after-discovered evidence for the purpose of vacating a verdict and a stipulation that the baggie of a weedy substance found in the suspect's pocket was really marijuana.
Well, that was our point all along, though. We're talking about a stipulation of fact versus a stipulation of credibility.
And there may be, with focused advocacy, a future case involving a stipulation to credibility at another stage of the case that the court may or may not see differently. If the court is convinced or is persuaded now that there are no differences in that setting, then the court can issue a broader ruling.
Well, we may not want to issue a blanket rule, but we may wish to opine on it, because we love to opine.
Of course, Your Honor.
Mr. Eisenberg, I understand your argument for judicial restraint. I'm not sure it would be dicta if we talked about it, but judicial restraint in doing as narrowly as possible to decide the case before us. Do you see a potential of creating a aberration in the law if this court was to say trial courts have an absolute right to have witnesses called to assess credibility?
I think what the court would say, and I think it's clear from the comments of all the justices, is that the trial judge has the right to exercise his discretion, which means that the trial judge could abuse his discretion. And like so many decisions that we entrust to trial judges, the power is broad but not unlimited because it can be reviewed for an abuse of discretion.
So therefore, it would not have been an abuse of discretion if the trial judge had done what he did here, even without any of that language in the remand from the Superior Court?
I don't think that the language from the Superior Court alone was enough to render the trial judge's result necessary. He certainly was important to him. He could hardly ignore it. If it hadn't happened, if there hadn't been that specific directive, and if the judge had instead simply said, I've seen your stipulation, I've read the stipulation, but I wasn't the trial judge and I want to hear the evidence again, I don't think that would have been an abuse of discretion either, even without the directive.
What if he had said, I want to accept this stipulation? Would that have been an abuse of discretion?
Excuse me, if he had said, I accept the stipulation, and I accept the stipulation and therefore I'm not going to have a hearing, well, that's an academic question since there would have been nobody to challenge it, Your Honor. I would think it would be better practice, certainly in the circumstances of a case like this with a new judge and with the Superior Court's directive, to hold a hearing. But again, we're not taking an all or nothing position here.
Counsel, could you address Commonwealth versus Williams, the Superior Court case dealing with Officer Graham? I think your brief talks about it. I think both of the parties' briefs talks about it, where the defendant was granted a new trial. Graham was, of course, the officer who had a notorious, publicized criminal episodes while engaged in being a police officer. That defendant got a new trial. Officer Graham was never called to testify. Trial court said, we got this. But the other thing in that case is Officer Graham was the only witness at that trial and could not be called by the Commonwealth. Doesn't that really take that case out of this whole notion of a stipulation as to credibility?
I think certainly the facts are different there, Your Honor. And while it's a little unclear to me what the Superior Court's analysis was there, I know what it should have been, which is, did the trial judge abuse his discretion or not? I don't know that the court specifically used the words, the trial judge abused his discretion. But because the standard is an abuse of discretion, certainly that's what the appellate court could be looking for. And there may well be cases, because this is not an all or nothing proposition, where a trial judge might abuse his or her discretion in refusing to accept a stipulation. This certainly is a different factual case, not only because of the Superior Court's directive, not only because the judge was a new judge, but because the witness really in question was this witness Perry from the trial, who was nowhere and was not sought out by the parties. So the judge was in a difficult position in trying to make those credibility determinations. Thank you very much, Your Honors.
Well argued by all three counsel.
Good morning. We granted a petition for certification of a question of law filed by the Third Circuit Court of Appeals to determine whether the use or threat of force is an element in Pennsylvania's first-degree aggravated assault statute. The government contends that the statute requires some use of physical force to prove an aggravated assault. The appellant argues that the use of or threat of use of force is not an element of aggravated assault and points to the Superior Court's decision in 2005 of Commonwealth versus Thomas. Again, and we accepted this because our court had never opined to the issue. So feel free to begin.
Thank you, Mr. Chief Justice, and may it please the court. My name is Brett Schweitzer from the Federal Defender, and it is an honor to appear before the court. The certified question has a straightforward answer, and that's that 2702A1 does not have an element, the use or threatened use of force. Instead, the actus reus is the causation or the attempted causation of serious bodily injury. That is clear from all indicators of meaning, the statutory text, the statutory context, the pattern jury instructions, the legislative history, and indeed Pennsylvania case law. To import a physical force requirement into Section A1 would usurp the legislature's prerogative and invite endless litigation over the scope and effect of that newly recognized requirement. The court should not open those floodgates, but instead should confirm Section A1's plain meaning. To begin with the text, it could not be clearer. The statute says the elements are either an attempt or a causation of serious bodily injury, plus a mens rea of knowing or extreme recklessness. Not only is a force requirement not in the text of the statute, but when we look at the text, we see something incompatible with a force requirement, and that is an attempt. An attempt here, in this context, of course, is an attempt of battery, which would mean an intent to commit a battery plus a substantial step. Neither of which, those two elements, require physical force or threatened physical force to the victim. So it's no surprise then, frankly, that the jury instructions are quite clear, and this is pattern instruction 15272B, when they say there are two elements of 2702A1, and of course that's causation of serious bodily injury and the mens rea. So if more were required here, we can also draw a negative inference from what the legislature has done in other statutes. Right in 2702, of course, in A4 and A6, the legislature provides for specific methods of infliction of bodily injury. In A4, of course, it's by a deadly weapon. In A6, it's by physical menace, which is essentially physical force or threatened physical force. Typically, these involve gun-pointing cases, as the court is aware. Yet in A1, there is no such requirement. Of course, we just have serious bodily injury. A neighboring provision, 2703, another assault statute, specifically says that requires assault by force likely to cause serious bodily injury. Again, nothing in A1, 2702A1 about force. And of course, perhaps most familiar to the court is the robbery provision in 3701A1, which defines robbery really in various ways, obviously, but including two, theft by bodily injury or theft accompanied by bodily injury, or theft separately in a separate subsection accompanied by force. So the legislature knows how to distinguish these things, knows how to require force, and simply does not in Section A1. As a matter of statutory interpretation, I think the court could stop there. But the Attorney General, at least, sort of hangs its hat on legislative history and points to the Model Penal Code. So 2702 is the adoption of the Model Penal Code, and somehow there's a hidden force element that was carried over from common law into 2702. That reading of the legislative history is simply wrong, respectfully. And if the court looks at the commentaries to the Model Penal Code, what it will see is that in the modernization of common law battery law, the Model Penal Code drafters chose to drop the common law contact requirement and instead place in its place the bodily injury requirement. That's what permits the holdings of, really the uniform holdings of the lower courts in this Commonwealth to find that neglect, typically child neglect cases, but also sometimes in the case of seniors, can constitute.
Let me interrupt you. We wanted to let you get your first statement.
I'm sorry. Wanted to let you get your premise out. I think the nub of the case, and if you disagree, tell me, is that our aggravated assault statute requires circumstances manifesting an extreme indifference to the value of human life. And at least at first blush, it's hard to see how one can manifest, I think that's an important word, extreme indifference to the value of human life, and yet not do anything, not lay hands on, not do something that is a violent act or is an act.
Of course, Your Honor. Section 301 defines an act as an omission or an affirmative act, and we don't dispute that. What you have, though, is it's the neglect cases, really. So that's primarily what we're talking about. And the question is it possible to, even with extreme recklessness or even knowing mens rea, is it possible to cause bodily injury without that contact requirement that frankly doesn't exist under 2702, but that existed under the common law? And the answer is plainly yes.
And we've answered that, right? The Nixon case from 2000.
Yes, Your Honor, and all of the cases in the Commonwealth are in accord here. So, for instance, in the Commonwealth, in fact, and the Superior Court, because the Commonwealth took the opposite position in the Thomas case, the Commonwealth and the Superior Court were correct in Thomas. There was no force there, but there was no, and there need not be any force. And the aggravated assault conviction was proper. Likewise in Pestinaikis, which is cited by the Attorney General, neglecting a 92-year-old can be, if death results, third-degree murder, but not because housing him in the country is force, or that there's any requirement for force under the murder under the definition of murder, but because force is not required under Section 301 and omission suffices. Likewise, Miller and Kellum, these are the infant cases. They're right too. There can be a third-degree murder conviction involving neglect of an infant, even though there's no restraint. In other words, even though there's no physical force. So the government, the United States, to a certain extent the Attorney General, again, with respect, I think tries to unduly complicates this case. There's a lot of argument about, or pre-argument, previews of federal arguments and so forth about whether we can look beyond the elements. We meaning from the federal perspective, ultimately what this case is about once it goes back to federal court. Does the federal court look past the elements? Is there some inherent underlying requirements that are behind the elements, all those sorts of things. Those are federal questions. We will debate that when we go back to federal court. Not surprisingly, I did not preview those in my briefing, but not surprisingly, we disagree about that. And so I would suggest to the court those issues are not before it. The Third Circuit really needs to know under the categorical approach. This court, I think, is perhaps not as familiar, but maybe becoming a bit more familiar. I saw in the AL case recently that the court adopted a similar approach for certain inquiries under state law. But the Third Circuit needs to know now just what are the elements. That's it. And then we answer that. The federal courts will go back and figure out what to do with that. I would only add, Your Honors, that reaching out to hold, again, in my position at least contrary to the text and everything else, that there is some sort of a force element or requirement in 2702A1 is a Pandora's box. I mean, first of all, it's a little peculiar to have the Attorney General at least sort of adding a requirement, adding an element to the offense. But I can assure you that the federal courts, where physical force is actually in the statute, so that's why they have to deal with this issue. They've been grappling with what does physical force mean for 20 years. And so not only would reading that type of a requirement into Pennsylvania law not be consistent with this court's normal approach to statutory construction, but it would also be a huge headache, frankly. What does that mean in future cases? What does that mean in past cases? Has any jury been instructed in an A1 prosecution about the hidden requirement of force? Has any defendant been allowed to argue against that, to present evidence that it was not forcible? Well, once in Thomas, and they were shot down, apparently, from our research. But if this court were to reach out and recognize some sort of a new element or new hidden requirement, it seems to me that that is a litigation engine, and again, a Pandora's box, both for past cases and for future cases.
Counsel,
Yes, Your Honor.
didn't the Third Circuit already go the way of your argument in the Mayo case?
It did, in fact.
So then what's the purpose of being here? Are they trying to overrule their Mayo case as opposed to going en banc?
Well, it's an interesting question. I can say I've pondered that myself. Unfortunately, I don't have, I'm not a fly on the wall, so I can't give a definitive answer. But what we do know is that this was decided before. And apparently, I view this as sort of a dot the I and cross the T, or a belt and suspenders approach in deference to federalism. And so, of course, in Mayo, the Third Circuit, not a huge leap, I mean, because I think this is clear as a matter of state statutory interpretation, but the Third Circuit predicted the elements of A1 and then went on to make its federal holdings.
They relied on Thomas, which was an intermediate appellate court case. And I presume this court accepted the question of cert with notwithstanding Mayo, because it recognized that Mayo was premised on Thomas, and before the federal courts adopted that, we wanted to look at it personally.
I think that's right, Your Honor. I think in the certification petition, the Third Circuit talked about they didn't see other cases, quote unquote, solidifying Thomas or whatnot. I don't think that's required. As Your Honors are aware, my first position in this proceeding was that the court should not accept the petition, either because there's no substantial question, or what I was pointing to, frankly, was the general prudential rule of this court that you don't decide previously decided questions. And so the Third Circuit's interpretation of Pennsylvania law obviously has no effect here in the Commonwealth courts. And so I think that would still be an appropriate resolution of this case. The court could dismiss the case is sort of improvidently granted, so to speak. But if it does not wish to do that, I would urge the court to interpret A1 just as it interprets other statutes all the time, and not create massive, in my opinion, what would be massive problems for the in the Commonwealth courts.
Pardon me, counsel, you're saying that we could economically dispose of the case by sending a one-paragraph memorandum back to the Third Circuit saying, you got it right in Mayo C. Thomas, thank you.
Yes, I think that could be done.
Mr. Have you ever heard of an instance where we have turned down a Third Circuit request for certification of a federal question?
I did. I can't say as I kept the case name in my mind, but when we were initially briefing the acceptance question, I did see that at least on 1 or 2 occasions, I thought in the last 5 or 10 years, that that certification was denied. I'd be happy to.
Prior to 2016, those denials were prior to 2016, I can tell you that. As a matter of comedy, it's difficult to say why one would say no when asked.
I absolutely understand that, Your Honor, and as Your Honor pointed out, there are other economical ways short of a dismissal to achieve the same result.
I think we put you in an uncomfortable position.
We can't remember, so we shouldn't expect you to remember.
We granted on this one, and we'll therefore deal with this one. You don't have to help us. Thank you.
Thank you.
You have anything else you want to add?
Any other questions, I'd be happy to answer.
Thank you. You did a fine job.
Thank you, Your Honors.
Good morning, Your Honor. May it please the court. Robert Zosmer on behalf of the United States.
Okay, thank you.
Thank you very much for the honor of appearing before this court. The categorical approach is an incredibly unusual doctrine of federal law, and I would imagine that state practitioners in this court probably feel fortunate when they see reference to it, that they don't have to deal with it on a daily basis as we do. And it leads us to some very strange places, and this may be one of them. What's strange about it, of course, is you're dealing with a question of recidivism. You're dealing with a question of when is an offender so serious an offender that he or she should be more sanctioned by the law.
But if I can interrupt, I respect that, and I understand you're wrestling with that, but we're not. See, recidivism is not it's your issue, I understand, down the street, but our issue is narrow, and it's just giving the Third Circuit the answer on whether use of physical force is required under our aggravated statute, having nothing to do with your statutes, and doesn't the case begin and end with simply asking whether we can hypothesize reasonably plausible hypotheticals that don't involve the use of force but nonetheless meet 2702? So the neglect cases would seem to answer that question clearly. What are we missing there, or what am I missing?
Thank you for the question, Your Honor. What is not the focus of this court and should not be the focus is what is, quote, physical force. That is a term of federal law. And what my friend, Mr. Schweitzer here, is doing very ably is seeking a home run. He's looking to get a court of this august stature to say a statute doesn't involve physical force, knowing how influential that will be with the Third Circuit. And it would be wrong. And the reason it would be wrong is that term physical force only appears in federal law. It's a term of art in the Armed Career Criminal Act. The Armed Career Criminal Act says a prior violent crime is one that has as an element the use, attempted use, or threatened use of physical force. That's the only place it appears. And the United States Supreme Court has said explicitly that this is a question of federal law. And what a state court has to say about it is not relevant. That's the Johnson case in 2010. The Johnson case in 2010 that we've cited involved the Supreme Court of Florida, which, much like the Superior Court in Thomas in this case, had said what is physical force and what is not. And the United States Supreme Court said, we don't care. We interpret what physical force means in the Armed Career Criminal Act. What we look to states for and to the state courts is to tell us what acts violate this statute.
No, counsel, I disagree with you there. I think what they're asking for is what are the elements? What acts can meet the elements is a different question. But the question we've got from the circuit is physical force an element of the crime, not an act that will equate to an element of the crime? And so I think there is a difference between mechanism and element. And why should we get into this discussion about what physical force is if I can just look at the statute and see, there's nothing about force, period. Physical, mental, emotional, anything that says. It's about effect, what is caused, and mens rea. It begins and ends there.
Thank you. That's a very fair question. The federal court is looking to what the elements are and looking to the state court definition. What we often do, though, and we litigate these categorical approach cases constantly, unfortunately, is we must look to the acts in state-reported cases to inform us as to what the elements are. So I appreciate the clarification. We are looking for the elements. But when we look to the elements of this statute, I think the answer to the Third Circuit's question is very clear. The elements of first-degree aggravated assault are clear. One has to show that the person attempted to use or inflicted serious bodily injury. And the other part of the question, the volition question, is informed by Section 301. It either has to be a volitional act or it has to be a failure to act by a person who has a duty to act.
But you would agree that in both of those scenarios, the General Assembly did not use any words regarding force, did not use the word force, or any derivative or equivalent of it.
I agree that the words physical force are not used. I also agree with my colleague, Mr. Eisenberg, who will address the court, that for all intents and purposes, serious bodily injury does equate, it actually more than meets the common law definition of physical force. And so, in fact, requiring proof of serious bodily injury is requiring physical force.
Could I jump in on that and ask you then, would you tell us how a parent convicted under 2702 has used physical force when she or he did not seek medical treatment for an injured child?
Well, there are two ways, Your Honor. First of all,
what was the physical force there?
Sure. First of all, the individual, in the starvation case, in the medical case, the individual does use physical force in the sense that he or she has to put the person in a place where help cannot be obtained. The starvation cases normally involve locking somebody in a room.
Let's assume it's an infant. The parent simply walks away.
If it's an infant, then the person has placed the infant in a place where help is not available.
Where's the physical force?
It's a physical act of putting the person there. The physical force is that the person is also taking advantage of the profound physical force that will then ensue that ends the person's life. What the Supreme Court, the U.S. Supreme Court has defined physical force as being common law force and has said simply that it is concrete action.
But see, counsel, let me interrupt you because you're going down that rabbit hole. We shouldn't care, nor should we look at how the United States Supreme Court defines physical force for this statute. We should simply look to the statute to see, is there any indicia of the General Assembly's intent to require proof of physical force to get a conviction under this statute? That's really what we should be looking at.
And what I'm saying, Your Honor, is that this court really should not concern itself with the concept of physical force at all. This court should define the elements of aggravated assault. Those elements are inflicting serious bodily injury, either directly or through an omission by a person.
Well, if we do, but that's what you're telling us that the answer to the Third Circuit certified question is to tell the Third Circuit is to quote the statute.
I believe that happens to be the case here. Some cases are simple. And then once that happens, once this court tells the Third Circuit the elements are plain, the elements are serious bodily injury with a volitional act or an omission by a person with a duty to act, it's then up to the Third Circuit to decide, is that, quote, physical force.
That's like telling the Third Circuit, stop asking us questions.
I can't speak for the Third Circuit, Your Honor. I was puzzled when I saw this question.
Counsel, may I ask you, I ran all the hypos, perhaps we all did, that you're reciting to us. And I must say that I had to caution myself that it seems to me that adopting those kinds of constructs, that walking away is physical force, that seeing the child in the bathtub drowning and not lifting a hand to help the child is physical force. And it seemed results-oriented to me rather than a fair, dispassionate statute. What occurred to me, and what I wanted to ask you about, is our statute is actually broader than what you're seeking. Our legislature might have been very aware and didn't want to put physical force in because they wanted to criminalize walking away from the child with a epileptic fit in the bathtub who's going to drown, and the parent who says, well, the child's better off anyway because of the medical problems, or walking away from the child in the crib that's starving or the like. So rather than narrowing aggravated assault, the Pennsylvania legislature has broadened it. Who are we to second-guess them and narrow it?
I am not second-guessing it at all, Your Honor. What I'm struggling with here is the idea that this court has to talk about, quote, physical force at all. It may well be that the state legislature has decided that what we all commonly consider physical force is not required. But for purposes...
Let me interrupt you just so we can get to the bottom of this. I hear you, and I've heard you say that before. Looking at the question that the Third Circuit certified to us, it's whether Pennsylvania's first-degree aggravated assault provision requires some use of physical force. Not in the U.S. Supreme Court parlance, not in the federal law parlance, as part of, whatever, 2702A1. So, you know, physical force can be part of many puzzles in the law. And we just have this narrow puzzle in front of us. But it does require that we decide that question, doesn't it?
Your Honor, I would suggest that the question be answered narrowly, which is asking what are the elements of aggravated assault, and specifically asking about the Thomas case. That is important, because the Thomas case said, in what I agree with Mr. Eisenberg's dictum, that force is not an element. It's important to address the Thomas case and confirm, and I think we're actually in agreement with the defense on this, that the Thomas case on the facts was correctly decided, that a person confining and beating and doing the terrible things that the defendant did in that case was first-degree aggravated assault under state law. That's what the Third Circuit needs to know, because it will then consider that in deciding, did what happened in that case amount to physical force under federal law? But I have to say that the first part of the Third Circuit's question is a puzzle to me. Asking this court, is, quote, physical force an element, when the only relevance of that term ever is in interpreting a provision of federal law that happens to use those two words.
So you want us to decide, and I'm going to have to go back and think hard on this. You want us to decide that Thomas was correctly decided when it said physical force is not an element of Pennsylvania law, and that's okay with you because you'll take that back and argue to the Third Circuit. It is an element of the Armed Career Criminal Act under federal law. Is that correct?
No, I don't believe that Thomas was correct. I believe it was actually dictum, the statement regarding force. What we would like this court to say, what we believe, is that Thomas correctly decided on the facts. That defendant committed first-degree aggravated assault by starving her child. That's the important fact.
But what you're not saying to me, I think, and again, and I'll stop badgering you and listen, but what you're trying to skip in the Thomas analysis is, or what you want to add to the Thomas analysis, is that parent committed first-degree aggravated assault on that child through physical force. That's what you want us to intimate. Is that correct?
Well, you can, but again, that reaches the federal question, because I do believe that, quote, physical force is only a physical question. But do I believe that that defendant used physical force? Absolutely. No question about it.
I apologize. Help me out here. Mathias versus U.S. Supreme Court case, specifically said the sentencing judge should look at the elements of the offending statute, not the facts of the offense. So looking at our statute, it's reasonable to conclude the words physical force are not included, not the facts of the incident, per Mathis. There's the answer. The answer is no, it does not include.
Well, Your Honor, again, we're in federal law now, and that's actually, I respectfully suggest, not the answer when we litigate these issues. The Supreme Court has never required that for a crime to involve physical force and thus be subject to the Armed Career Criminal Act, that the statute use the words physical force. What the court looks to instead are what are the elements informed by the facts that have been found to establish those elements. And what the Supreme Court has often said, and this gets to Your Honor's question about Mayo, this is why we have so vigorously argued for years that Mayo was wrongly decided, and why we're grateful that the Third Circuit is apparently taking it up again. The Supreme Court has explicitly said that in multiple cases, that a requirement of bodily injury, exactly what we have in this aggravated assault statute, that a requirement of bodily injury equates with physical force, as it is stated in the Armed Career Criminal Act. So when I get back to the Third Circuit one day, that's what I'm going to be reminding the Third Circuit of, that the Supreme Court has said these words in the Pennsylvania statute meet the physical force requirement in the Armed Career Criminal Act, and Mayo was wrongly decided. Again, what we come back to here is we need to know the elements of this state offense. And
again, I'm kind of going back to this. Your approach to our response to the Third Circuit's question is, dear Third Circuit, the elements are serious bodily injury and intent, and the words physical force do not appear in the statute. Have a good day. It doesn't give the Third Circuit anything. I mean, judges are very capable of reading reading the statute themselves. But that's what you're essentially asking us to do, is to say, here's our statute, and so you can go back and argue, you got your answer from the Pennsylvania Supreme Court. They told you what the statute says.
I am asking you to do that exactly, Your Honor, because I think that's the right answer. And the Third Circuit decided that it wanted to hear from this court.
How do you think the Third Circuit would react if we did that?
I think they would be happy to accept that answer, and then I'm sure Mr. Schweitzer and I will be back in our usual places arguing about it to the Third Circuit. And I think that would be, it's not only acceptable, but it's right. The elements of the statute, it's not always plain as day, but it is plain as day in this case. Now, I will say,
it may be plain as day, but in the opposite direction. Because again, you seem to neglect an entire category of hypotheticals, some of which have become real cases of omission to act. And it tortures the words physical force to construe such circumstances as involving physical force. I mean, if you want to go down to the federal court and argue to them about what SCOTUS has said about physical force in the context of federal law, certainly that's fine. But to get us to tell you that our statute includes physical forces is entirely contrary to the text of the statute that we have in front of us right here.
Let me address that, Your Honor. Again, physical force, the only place that appears in this case, is a federal term of art in the Armed Career Criminal Act. And in fact, numerous courts have held that an omission to act by a person with a duty to act is physical force under that specific federal statute. And we cited all of those cases in our brief. Just for one, I'll call this court's attention to the Scott case, which is an exhaustive en banc decision of the Second Circuit on the very issue that Your Honor is talking about. On that federal issue, does someone, quote, use physical force when they have a duty to act and stand back while physical properties go to work and murder someone. All the other circuits, I think about 8 or 9 of them, are unanimous in interpreting the Armed Career Criminal Act to include that.
So I may, Councilman, I may have a conundrum then, because I am leaning of a view that physical force doesn't include acts or omissions. But you're telling me federal law includes within physical force acts or omissions. How then am I supposed to answer the Third Circuit certified question under my view of what the definition of physical force is in contrast to the view that pervades the federal jurisprudence?
Your Honor, I think your opinion regarding what physical force is certainly deserves respect, but again, it's a question of federal law. And that if your view is that these...
Then why did the Third Circuit send the question?
I can't answer that question.
Yeah, well, but your answer is they sent it erroneously because they know very well what physical force is. Every circuit that's considered it has decided it includes a failure to act, and it's self-evident that the Pennsylvania Supreme Court would be moronic to not adopt this universally held definition, which would take care of the question.
My guess is that the question was certified because of the statement in the Thomas case of the Intermediate Court, which said the use of force is not an element, and that properly leads the Third Circuit to ask, how exactly do you look at this state statute?
But counsel, you're asking us to apply federal jurisprudence to interpret a Pennsylvania statute. The Third Circuit is asking us to apply Pennsylvania's statutory construction principles to a state statute, which brings us back to where Justice Wecht is. I mean, the face of this statute is clear. It has 2 elements, and not either of them involves physical force in the context of statutory interpretation that we would do under Pennsylvania law.
So I am absolutely not asking this court to apply federal jurisprudence. I am pointing out that it is a separate federal question. The United States Supreme Court has told us explicitly that I cannot ask this court to answer the federal question for us. What I'm pointing out is that the Third Circuit needs to know what the elements of this crime are. And the elements of the crime are attempted or infliction of serious bodily injury, either volitionally or by omission by a person with a duty to act.
Respectfully, the Third Circuit asked us to answer a precise question, and that is whether it requires some use of physical force. I mean, that's the question we.
I think I understand. I think I understand where you're going, and correct me if I'm wrong. The issue is Thomas.
Right.
If we get rid of Thomas and say nothing more, we just say that line in Thomas was dicta and nothing more. It leaves everything else sufficiently ambiguous that you will argue in the Third Circuit what you're going to argue. Because if Thomas goes away and we say nothing, you get to continue to argue your federal jurisprudence of bodily and whether serious bodily injury requires physical force. Thomas is the problem.
I think that's right. That one sentence in Thomas is the problem. Interestingly, the facts in Thomas and the result in Thomas are not a problem. That defendant did use physical force to murder her child.
But that doesn't matter.
It doesn't matter, exactly. It does. If I could just say one more thing.
Yeah, I really believe that notwithstanding some frustration up here, we understand your argument, and so take a sentence and finish up for us.
Well, my sentence will be, listen to what Mr. Eisenberg has to say, because in terms of whether, as an academic question, this statute requires physical force as it's defined by the common law, I think the answer to that is also yes, and that's what he's going to talk about.
I think we should ask Mr. Eisenberg to argue third in every case in the future.
No problem with that. Thank you very much.
Thank you very much for your time and for coming over here today.
May it please the court, Ronald Eisenberg for the Amicus Attorney General's Office. Thank you, Justice Todd.
Let's talk about Pennsylvania law. Please go ahead for a couple minutes. We'll
Yes,
try
Your
not to
Honor,
interrupt.
and we haven't spoken about the federal law. I've left that to our federal partner. We've only spoken about Pennsylvania law and its antecedents, and we've done that to follow up on your questions, Justice Brobson, because on the one hand, one can just look at the statute, and on the other hand, if that's all we do, then all we're doing is sending back to the Third Circuit a copy of our statute, which is obviously not what they want, which means we must go beyond the mere words of the statute. They are asking us to do that because they could read the statute on their own. And when we go beyond the words of the statute, we come to its history, its basis, which is the Model Penal Code. And I think the problem here is that there's been some confusion by the defense between absence of force and degree of force, and between direct force, like punching, and indirect force, like abandonment or isolation or exposure. And the Model Penal Code makes it very clear that causing bodily injury includes the latter, includes that kind of indirect force, which, Justice Wecht, you have referred to as neglect. The Model Penal Code doesn't say it that way. It says bodily injury, quote unquote, includes more than the consequences of direct attack. It also covers pain, illness, or physical impairment caused indirectly, as for example by exposing another to inclement weather or by non-therapeutic administration of a drug or narcotic. And it goes on to also cite the situation of abandonment or of a young child. All of these are included in the definition, in the meaning of bodily injury. So the
Why should this court accept that when the second part of our statute says manifest an indifference?
Because the additional language of manifest indifference doesn't change the definition of bodily.
But it encompasses all those acts of negligence, starvation, neglect. I would easily, as a trial judge, convict someone of aggravated assault for starving a child under manifesting an indifference to the value of human life, hands down.
Justice Doherty, aggravated assault requires that additional element. Simple assault merely requires bodily injury, and what I've read to you is the definition of bodily injury. So that definition is encompassed in aggravated assault. The question before the court from the Third Circuit really doesn't depend on simple versus aggravated assault for our purposes. They've limited their inquiry to this question of bodily injury and whether it includes force. And when you look at the cases that the defense relies on, their arguments all carry over that confusion between absence of versus degree of force, between direct force versus indirect force, ignoring what the Model Penal Code tells us is the definition of bodily injury.
Doesn't your argument mean, Mr. Eisenberg, that anytime anything bad happens in the world, we would necessarily have to deem it a use of force, right? Really, on a cosmic level.
No, Your Honor.
I mean, isn't that essentially what you're arguing? Because you're asking us to look at the words of the statute and find ambiguity where it doesn't seem to exist.
There's no ambiguity, Your Honor. I'm reading you what the Model Penal Code says the term means, and actually I think the problem is exactly the opposite of from what you've addressed.
We're not talking about the Model Penal Code, we're talking about the Pennsylvania statute.
Yes, which is an exact model of the Model Penal Code. We took every single word.
Okay, well, those comments are not part of our statute.
They're not binding, but they're certainly
They're not,
informative.
and we don't look to it unless it's ambiguous.
And they make sense because of the point that I'm going to make now, Your Honor, which is that it is the defense position which broadens the meaning of our statute in a way that encompasses all sorts of problematic behavior that it's not really clear anybody really means to be assault or aggravated assault. It's ironic that the defense wants to broaden the meaning of our statute because by doing so, he limits his federal exposure because our statute becomes broader than theirs. But that leaves Pennsylvania with a statute that covers lots of people who I don't think were covered before. So in other words, we are increasing criminal liability by saying that our statute doesn't require force.
Well, counsel, but you're saying, so if I understand what you're saying the statute does require force, not expressly, but because the definition we should ascribe as serious bodily injury, if we were to define what serious bodily injury means, as if we don't have a common understanding to it, it must include physical force.
Yes, some kind of application of physical force, which is not just direct.
So what definition of physical force do we need to look at to determine whether, because again, the Third Circuit can read our statute presumably they can read the Model Penal Code comments and arise at this same conclusion.
Well,
what definition of physical force should we be looking at to determine whether serious bodily injury, which is in our statute, includes a hidden element of physical force?
Your Honor,
And I propose we allow him to answer this question.
Thank you, Justice Todd. The whole point is it's not a hidden element. There are many statutory phrases which are not further defined, and what happens is people go to court and courts figure out what those words mean. Not every single word in any statute is further defined, and if it were, there would be words in the definition which are not further defined, which would have to be defined, and somebody has to do that. That's where statutory interpretation comes into play. And as I've said, the defense view of this statute would actually broaden its impact and lead us into, the court has used the word over and over, various hypotheticals, which I think brings me to a very important point, which is how should the court be responding to the Third Circuit? Well, the U.S. Supreme Court has told us some information about how to do that. And what the court has said in the Gonzalez case in our brief is that state courts and federal courts really shouldn't be engaging in legal imagination. They should be looking at the way that statutes are actually applied, the reasonable probability of the way that they're applied, not the theoretical possibilities of ways in which they'd be applied. And the defense argument basically is that if we theorize enough, if we hypothesize enough, we can think of cases where somebody might cause bodily injury without using force. And that's exactly what the court is not supposed to do in answering the Third Circuit. And this touches on, Justice Brobson's, your point about Thomas. The question certified from the Third Circuit was not just, tell me what the statute says. It was, tell me about Thomas. The first part of that question would be meaningless because we would just send them back the statute. It's the second part of the question which is the important one. It's the second part of the question which was discussed at length by the Third Circuit in the petition in support of certification, and it's the second part of the question, Thomas, that was relied on by the Third Circuit in the Mayo case. The Mayo opinion specifically says that Pennsylvania case law establishes that a person who violates the statute by causing injury, regardless of whether the injury results from physical force, see Thomas. That's the basis for what the Third Circuit has done.
But Mr. Eisenberg, you're respectfully taking us in a big circle, because if we adopt physical force as part of our statute and then define it to be both affirmative and implicit in a negative act, walking away from the starving child is the use of physical force, allowing the baby to drown to death is the use of physical force, then for the feds can do what they want with that in terms of the Armed Criminal Act. But what we've done is left our statute as is by adopting physical force for the convenience of the federal advocacy position here, but defined it so as to not change our broader statute.
Your Honor, I'm not sure that I follow, but I do believe that it is the defense position which asks you to change the statute, the Pennsylvania statute, in order to, ironically, limit the federal exposure. The Pennsylvania, we don't have a lot of background or case law on which to figure out what the statute means by bodily injury. We've got the Model Penal Code. We haven't had to address this particular question before because it doesn't matter for Pennsylvania state law purposes. It matters to the federal courts. And that's where this Gonzalez case comes in, because it tells us how far we should go in hypothesizing possible answers to this question in order to satisfy the Third Circuit.
But isn't the question, counsel, that really it's in that realm where we delineate between circumstances where a person owes a duty of care and the larger category where there's no duty of care required. So, we're not required in American American jurisprudence to be a good Samaritan, but if we are a parent or a police officer or certain other circumstances, we may owe a duty of care. So this category of cases which are caught by 2702 because somebody exhibited extreme indifference, those are cases where somebody can be convicted of aggravated assault, but they don't involve any force whatsoever. They just mean that somebody breached their duty. It seems to me you're missing that entire realm of cases.
Actually, Your Honor, I think it's the question which engages in the kind of hypothesizing that we're not supposed to do, that we're not required to do, and that we should not do in answering the Third Circuit. And that is because the role of, say, omissions is a complicated one that the court has not addressed, and I don't think has to address. Does omission mean lack of force? I'm not sure that it does. What I know is that the statute says bodily injury. Bodily injury means, we are told by the drafters of that statutory language, means both direct and indirect force. And beyond that, we are essentially writing a law review article for the Third Circuit. What could the meaning of bodily injury possibly be in this scenario and that scenario, et cetera? Is it merely a question of duty? I would say that the cases that we have are not simply a question of duty. The cases that have been decided, that we discussed in our brief, those are cases where some degree of force was used, and it's less force than is commonly at issue in an assault case, because if you're an infant or an elderly invalid, it doesn't take a lot of force in order to cause bodily injury. And the force doesn't have to be directly applied.
Counsel, you're creating an ambiguity where none exists in the statute. You get to the model penal code only because you have to argue that somehow bodily injury is an ambiguous term that we have to look outside of the context of the statute for a definition. And I think most everyone up here would have a hard time doing that. We would never just say, well, why don't we go to the dictionary? We wouldn't go to the dictionary. You want to know why? Because it's not an ambiguous term. On the face of this statute, I don't know where the ambiguity is when put in the context of the certified questions that we agreed to answer. And if we answer the first part of the question, does it require use of physical force, and we say no, the answer to the second question would be Thomas was right, because the only question that it asked is, was Thomas right, was it correct when it said the use of force or threat of force is not an element of the crime? We're answering that in the first question. No, it is not. Yes, that statement in Thomas is correct. So this getting to the model penal code is just the leap that I can't take here in terms of interpreting the statute.
Justice Donahue, if there's no ambiguity in the statute, then really all we have to do is send them a copy or a citation to the statute. Probably the citation's enough. They could look it up for themselves. Obviously,
maybe that's correct.
Obviously, they think there's some ambiguity in the statute. They're not allowed to certify it to this court unless they think there's some ambiguity. And the reason they think there's the ambiguity is because of Thomas. Justice Brobson.
That's what I wanted to get back to.
Thomas is the problem.
If we said to the Third Circuit, you should not, Third Circuit, interpret Thomas's language as precluding you from applying federal law to determine whether our statute requires physical force as that term is defined under federal law. Does that take care of this problem?
I think it might, Your Honor, because, as I said before, it's clear that their problem is Thomas, not the language of the statute. They don't believe that the statute...
Thomas may be right on our view of what physical force is in our world, in Pennsylvania world. The Third Circuit, sounds like the Third Circuit has taken what the Superior Court wrote in Thomas in use of physical force and overlaid the federal definition. And that may have been where the mistake was made, was for the federal Third Circuit to assume that the language of the Superior Court was using a definition of coterminous with the federal definition.
I think that's an excellent point, Your Honor, and I think that that is true. I also think it's true that under any norms of reading judicial opinions, the one-sentence uncited statement in Thomas was dicta. The boy in Thomas had 4 fractured ribs on top of everything else. The court itself used the word force later in the opinion. The court didn't cite to anything for that assertion, and no one has ever cited, until the federal courts came along, no one has ever cited Thomas for that proposition. So to say that Thomas is a holding on the use of force, I think, was a mistake by the federal courts. Now, the defense has argued, well, even the Commonwealth in Thomas argued in its briefing that force wasn't required. And I do often wish that whatever the Commonwealth argues in its briefs becomes the law of Pennsylvania. But in reality, that's not the way it works, and that's not the Third Circuit's reading of Thomas was not an appropriate reading of Thomas. And to ask this court to engage in legal imagination, to decide in this case, well, does it require a duty? Is omission the same as commission? Where does force fit into that? I think goes beyond the bounds of what federal courts are supposed to be doing when they look at state law.
Thank you very much.
Marion versus Bryn Mawr Trust Company. Representing Bryn Mawr Trust is Mr. Michael McKinley. Representing Mr. Marion is Mr. Koch.
All right. Robert Bentley orchestrated a Ponzi scheme using Bentley Financial Services as his bank. The federal court appointed a Mr. Marion as a receiver to attempt to recoup monies lost in the Ponzi scheme, and Mr. Marion sued Bentley Financial Services, arguing it aided and abetted Mr. Bentley. We accepted review to consider whether we should adopt Section 876B of the Restatement Second of Torts for aiding and abating the alleged fraud by Bentley. Assuming that we adopt this section, the second question is whether the bank must have actual knowledge of the fraud or should have known or something in between. And then finally, we agreed to consider whether the prior jury's verdict, which has already been vacated, but which found no liability against Bentley prior to vacation, barred further relief. And I would advise you to look more to the first two questions, and I think you'll have a better opportunity. Mr. McGinley?
Thank you, Your Honor. Mr. Chief Justice, and may it please the Court, my name is Michael McGinley of Deckert LLP on behalf of the Bryn Mawr Trust Company. And the one thing I would just want to mention with your summary, Your Honor, is that I believe you misspoke and said that the receiver sued Bentley Financial Services. He sued Bryn Mawr Trust Company.
Oh, I'm sorry.
That's
Thank
okay.
you.
As you mentioned, the court granted on 3 questions. I'll take each in turn. On the first question, this court has never recognized a tort for aiding and abetting fraud, and it should not do so now. As our briefs explain, there's a number of existing torts that amply cover any actionable conduct that would fall within an aiding and abetting fraud claim. Adding a new tort to the mix now would only add confusion in the doctrine and invite vexatious lawsuits. And that's a...
Sure. Seems to be the catch-all every time a case comes up here. Tell me how this is going to open the floodgates or create vexatious lawsuits
Sure, Your Honor. And I would say, I think especially in the banking context, that's true, and that's because we have the UFA, which covers claims against depositaries for actions of their depositors. And in that context, the legislature has struck a very careful balance to say that there can be liability if the depositary knew of the misconduct or that the evidence was so compelling that it was an act of bad faith not to know about it. And so when the legislature has spoken on a question, as it has in the UFA, this court has been very clear that it treads carefully and does not, and is very cautious to not usurp the legislature's judgment in that context. So I think that's precisely the case here within this case. I think this case actually quite illustrates the fact that the receiver had no lack of claims available to him here. He had a lack of evidence to support those claims. And so in this case, what happened is that he brought claims for negligence and the UFA. He also brought an aiding and abetting fraud claim. He was able to try the negligence and UFA claims to the jury. The jury rejected liability in those claims. And the trial judge, and I would commend the court to look at the trial judge's post-trial opinion, extensively deals with the evidence and says it's not available. The receiver has not said why having this aiding and abetting fraud claim would be better for him, except maybe under the diluted theory that he and the Superior Court adopted. But even that falls squarely within the shadow of negligence. And that's why we think on the third question, and I will be mindful of Your Honor's admonition, I think on the third question, we do think it's quite clear that the jury was presented with precisely the standards that the Superior Court says should be available under this tort, and it rejected liability in that context. So I do think that in this context, adding something to the mix will only make people think, well, why is there some new thing? Is it different than the UFA? Was the legislature incorrect in how it crafted the UFA? Has the Pennsylvania Supreme Court somehow usurped or preempted the UFA? And I don't think the court should do so here. I would also say that, in some sense, the burden of history is on the other side here, because this court hasn't ever recognized this tort. The other side says that in Skipworth, the court sort of implicitly did so. I would point out two things with respect to Skipworth. One, that's a 876A case that dealt with a common scheme or purpose. And even within that context, the court didn't adopt 876 blanket, let alone even 876A. Instead, in dicta, what it essentially said was that the lower courts have applied a standard that says if the plaintiff cannot identify the primary tortfeasor or the secondary tortfeasor, you can't have a claim under that provision. And the court said that seems reasonable, and without addressing whether or not we're adopting the tort, will say that in that case the facts didn't support the plaintiff's claim. And then I would say in PwC, which was a case decided after Skipworth, that was on certification from the Third Circuit, this court, in I believe it was footnote 14 of that decision, very explicitly says that this court has not adopted 876 and declined to do so in the context of that case. So we believe that it's clear this court has never adopted. I'm sorry. So the Kochen case from the Commonwealth Court does seem to adopt an 876 liability theory. Obviously, that's not binding on this court. I think it's not entirely clear, but I think even in that case, it was more likely that it was proceeding under 876A. And 876A, I think, is quite fairly read as essentially being a civil conspiracy element, because 876A says there has to be a common purpose or plan, whereas 876B is more of the traditional aiding and abetting concept, which says that the defendant must know and substantially assist or encourage the act. And so I don't think Kochen obviously doesn't bind this court, and I don't think that it should really inform the court in this context either.
Counsel, if you would, could you go through the elements of a UFA claim?
The elements of a UFA claim are that there is a fiduciary, and that the fiduciary committed a fraud that either was known to the depositary, in this case the bank, or that the evidence was so compelling that it was an act of bad faith for the depositary not to step in and investigate.
And why do you think that the adoption of the restatement section before us would somehow interfere with that particular claim?
So in the context of banking, where there is an allegation of a relationship where the depositary is accused of somehow aiding and abetting the fraud of the depositor, who in that context is alleged to be a fiduciary, then I do think that adding 876B to the mix would create confusion as to whether or not the limits set forth in the UFA continue to apply. Now, I will...
There would be no confusion. It would just be an additional tort. Why is that wrong?
Well, I think what the confusion would be how is a court or a jury to assess what the relevant standard of liability is?
Well, I mean, that's the case when you have a negligence claim up against fraud claims, et cetera, et cetera. I mean, juries always have to sort out different causes of action.
Well, that's true, Your Honor, and of course they could do so here, but I think what this court has said is that when it's asked to adopt a new tort, one of the questions it asks is whether it's necessary to do so within that context, and part of that question is, has the legislature addressed it, or is it more appropriate for the legislature as the policy-making body of the Commonwealth to address that question? And what I submit is that in this particular context, it may be that in a context that doesn't involve depositors and depositaries that maybe the court might want to take up the question in that context, but here, where you have the UFA, I think the law amply covers any conduct that might be viewed as actionable. And I think the more prudent course would be to not adopt the tort.
So your argument then is you don't have a problem with us adopting the tort, you just don't want us to adopt the tort as applied to your client?
No, Your Honor. What I'm saying is that this court has said, when addressing questions about whether or not it should adopt a new tort in a particular context, that it should do so in a way that's mindful of whether or not the legislature is the one who should be creating policy in that context, and whether it has. And so I think in this context, there's an argument that it's most prudent to say that the UFA covers this, and the UFA sets certain.
Well, but so I understand that that's the standard, but I'm saying what you're saying is wait for a different context to adopt the tort. And if we adopt the tort under a different context, it's going to be adopted for everybody, right? We're not going to say except financial institutions because of the UFA. If there's different facts in a different case that comes before us that doesn't involve a financial institution, and we say we hereby adopt the aiding and abetting tort, we're not going to carve out financial institutions, are we?
Well, I mean, you could, Your Honor. You could say in the UFA, in the context of that setting, the legislature has spoken specifically through the UFA to that context. The other thing you could do, Your Honor, if you're not comfortable with that approach, and this is sort of segueing to the second question presented, is that we think under any permissible adoption of 876B, the standard would essentially be the same as the UFA, if not stricter, right? Because under 876B, it requires knowledge, which is actual knowledge, and under the UFA, it requires actual knowledge or bad faith. And so, you know, it may be that if you're uncomfortable with the notion that you should tread carefully and not carve out a new tort in this context, that the standards essentially resolve to the same, and you could say so within this case.
Procedurally, this case is going back for a new trial. Is that correct?
We don't believe that's correct, Your Honor. If you decide to address the third question presented, that you did grant aliquotter on, and that question says asks whether or not the no liability verdict that the jury rendered with respect to the negligence and UFA claims necessarily bars relief here. We think it does. If you look at the instructions that the trial court gave to the jury, and if you look at the verdict form,
you know, that we have a lot of cases to get ready, and it's not clear in my mind, and I think it's worthy of you explaining. The Superior Court in this case vacated the verdict and provided a new trial. And you're saying go behind that ruling and look very carefully, I think what you're saying, look very carefully at it, and in this one aspect of that ruling, it provided, notwithstanding the new trial, it verified what we were arguing, and therefore we don't have to try this case again. even though the Superior Court did not put that in that mandate, in their mandate. Is that accurate?
I'm not sure. I'll try to clarify our position, Your Honor. So what the Superior Court said after finding that the tort existed and then applying its lax standard of scienter, it said, we don't need to address whether or not there was harmless error here based on the no liability verdict because we've thrown that verdict out. And what we've argued in the briefs and what we think is fairly encompassed within the third question presented that the court granted for review is that the Superior Court's vacature of that jury verdict was patently incorrect and violated basic norms of appellate review. In particular, what the Superior Court said was that mitigation evidence, some of which the jury was precluded from even considering, somehow infected a no liability verdict, even though the trial court had specifically instructed the jury not to consider anything but BMT's conduct when assessing liability, had specifically structured the verdict form, which the receiver didn't object to, so that if the jury found no liability, it was instructed not to consider damages at all, but instead to return to the courtroom and render a no liability verdict, which is precisely what happened here within just a few hours. And therefore, the Superior Court, to reach its holding that vacated the jury verdict, it had to overlook one of the most basic rules of appellate review, which is that jurors are presumed to follow the instructions that the trial court gives it. And I think that's really important, and I don't want this court to be left with the misimpression that that's a small issue. A jury verdict is the gold standard of justice within this Commonwealth and within this country, and I think that what the Superior Court did in basically supplanting its own view for that of both the trial court but also of the jury was a direct contradiction of that rule.
Are you arguing here that we should reverse the Superior Court's decision in toto and affirm the trial court, as you say, the jury verdict of the trial court?
Correct, Your Honor.
But I'm not sure that's before us, the way you structured the questions.
No, I believe that it is, Your Honor, because to answer the third question, which asks whether or not the no liability verdict necessarily barred relief under essentially any standard of mens rea under 876B, the court would first have to address whether or not the no liability verdict was still valid. And so the antecedent question to deciding the third QP is whether the verdict should have been vacated by the Superior Court. The County of Butler case makes it clear that this court plainly has the power to decide any question that's fairly encompassed within the questions that it has granted. And
except we denied allowance of appeal on that precise issue.
I don't. So you denied allowance of appeal on the first question presented, which we think was sort of a broader question of sort of what is the proper standard for addressing whether to overturn a jury verdict. And so it obviously, I will not deign to tell the court what it was thinking when it did so, but it may very well have been that this court said, we don't need to address what's the standard of review. We know what the standard of review is. That's not an open question under Pennsylvania law. But then the court did grant the third question presented within the aiding and abetting bundle, and that question necessarily requires the court to decide whether or not the verdict remains valid, because otherwise it wouldn't be able to assess whether the Superior Court should have viewed that verdict as necessarily barring relief under an aiding and abetting fraud theory.
So if you put this in the context of the petition for allowance of appeal, where we denied the precise issue that you're now arguing, we would then have to decide the third issue by saying the Superior Court erred, and then you don't have a no liability verdict, and then we're left with the two issues that are the crux of this case.
Correct, Your Honor. I think there's logic to that, because essentially what you would have been doing by granting that third...
You don't want to agree with me, because what I'm saying is we would say the Superior Court, the trial court erred. The Superior Court was correct. Therefore, there is no liability verdict. So let's get to the two questions that are going to be heard on the retrial.
Okay, sorry, I misunderstood, Your Honor. I thought you were...
We denied the allowance of appeal on the precise issue that you're arguing, and I understand the confusion given the way the rest of the issue was phrased, but we did deny allowance of appeal on that alleged error by the Superior Court.
Understood, Your Honor. We think that the third question presented is a narrower version of that we think you can decide, but I'm not going to
You
quarrel
think
with
you
Your
think it falls into the C part, failed to recognize the jury's no liability finding necessarily barred relief.
Honor. Correct, Your Honor. We think that to decide that question.
We took that question.
You took that question, and we think that to decide that question, you have to decide whether or not the verdict was valid. And the reason the Superior Court chose not to address that question is it said, well, we've overturned that verdict, so we're just not going to decide it. But you granted review on that third question, which we think fairly encompasses the narrow question of within the context of this case, should that verdict have been overturned, and we don't believe that it should have been.
We understand your position. Would you like to say anything in conclusion?
Nothing other than to say thank you for the opportunity to address the court, and if you have any further questions, I'm happy to answer them.
Thank you very much.
Thank you, Your Honor.
Mr. Coach. Is that Cock or Coach?
Good morning, Your Honor. It's Edward Koch, like
Koch?
Scotch tape. We're the former mayor of New York. Same name.
Thank you.
May it please the court, my name is Edward Koch. I'm proud to represent the receiver in this case, David Marion. I believe Mr. Marion is well known to this court. This case represents the final piece in a 2 decades old journey for Mr. Marion to marshal the assets of Bentley Financial and Trust to repay the victims of the scheme. Why did we sue Bryn Mawr Trust? You can't have a Ponzi scheme of this nature without a bank. You can't have a Ponzi scheme of this nature without a bank that looks the other way. So Bryn Mawr Trust was the instrumentality of the fraud. Turning to the issues that the court granted appeal on, we obviously agree with Justice Donahue that the court's limited grant of appeal is clear on its face. When looking at Bryn Mawr Trust petition for allowance of appeal, issue 1 was the 2 evidentiary issues in which the Superior Court granted a new trial. Issue 3 was the aiding and abetting claim. The court said, we are granting on the aiding and abetting and the 3 issues, and we are denying on the remaining issue. So I don't think we need to spend a lot of time on whether Mr. Marion is entitled to a new trial. The Superior Court has said that he is entitled to a new trial on the negligence and UFA claims. The only issue before this court is whether that new trial will include an aiding and abetting fraud claim, and if so, what the required mental state is. I would respectfully submit that there's no option for this court under its own limited grant of appeal to reinstate the jury's verdict. There will be a new trial under this court's limited grant of appeal again.
Well, we understand that. Why don't you move on to the...
Understood.
Should we adopt 876B, or should we conclude that the Financial Act covers it and it would be duplicative?
Sure. Your Honor, in Skipworth, this court called the tort eminently reasonable. We have decisions from the Superior Court and the Commonwealth Court that not only approve of an 876B tort, they adopt it. So if we look as far back as Klein, the tort has been in existence for 40 years in Pennsylvania. That's a 1982 case. So I respectfully disagree with Bryn Mawr Trust that this is a novel or new cause of action. It has been a part of the jurisprudence of this Commonwealth for, depending on which case you look as the starting point, either 40 years or 25 years. And as this court, I'm sure is well aware, where this court has not expressly spoken, decisions of the intermediate appellate courts are otherwise, binding on the lower court. So we have consistency among the Commonwealth and Superior Courts adopting the tort.
Well, I'd like to just explore that for a moment. Are these cases examples of the courts adopting the tort, or was it more inferentially that we are going to accept the tort? Because they aren't quite as clear as I think you're holding them out to be. But they aren't quite as unclear as you're opposing counsel held them up to.
So, Your Honor, for example, in Sovereign Bank versus Valentino, this is a 2006 Pennsylvania Superior Court case. The Superior Court says, we expressly recognize the tort of concerted tortious action. Concerted tortious action, as defined in 876, is a recognized civil cause of action, and it's also known as civil aiding and abetting. So while you raise an excellent point, Justice Todd, are the ruminations law in the other cases? I would suggest yes, but that issue is settled once and for all in the Valentino case, where it's an express adoption.
Counsel, this restatement section that we're talking about, this isn't a large leap in terms of adoption of a cause of action, is it?
No, it's not, Your Honor.
I mean, forget about the cases that allegedly adopt or don't adopt 876. The notion of two tortfeasors acting in concert are liable to be victim harmed is not a unusual manner in which this court establishes tort liability, is it?
Not in the least, Your Honor. This is, it is an ordinary principle of existing jurisprudence that multiple tortfeasors can be liable for damages. 876 merely says, here's an example, one can aid and abet another's commission of a tort. This concept is throughout this Commonwealth's criminal jurisprudence in terms of aiding and abetting. You're absolutely right, Justice Donahue. This is not a leap at all. This is not a sky is falling if you adopt it. Again, we respectfully submit that this court, through Skipworth and the other decisions, it's been adopted in Pennsylvania. But
may I ask
Counsel,
you?
You just mentioned criminal cases. It reminds me of the disconnect I perceive on your scienter argument, because assuming you're right about the tort, why should we allow this with a lesser level of scienter than actual knowledge? I mean, doesn't the very definition of aiding and abetting suggest some higher standard?
Your Honor, an excellent point. To be clear, the Superior Court did adopt an actual knowledge or should have known standard. Here's the problem with fraud. Fraud is rarely proclaimed from the mountaintop. Rare is the case where you have a witness saying, for example, in this case, you know what, we actually knew Mr. Bentley was committing fraud and we continued to service his accounts anyway. Or rare is the case where there's a smoking gun document that says, bulletin to all Bryn Mawr Bank employees, Mr. Bentley is committing fraud. Fraud is almost always shown through circumstantial evidence. Justice Kennedy in the Globtech case talked about facts demonstrating willful blindness are also probative of actual fraud. One can infer knowledge from the conduct, and an inference may be justified when a defendant avoids confirming what may be true.
Well, that's more of a recklessness standard, though. It's not negligence. It's more than that, isn't it?
It is. It is more than that, Your Honor. And it's not a standardless exercise. The Kedrick case, for example, talked about in assessing the circumstantial evidence as evidence of actual fraud or something else, was the risk obvious or a matter of common sense? Did the defendant have particular training or expertise? Did the defendant violate procedures designed to address that harm? In this case, you answered that question respectfully. Yes, yes, yes. It was a matter of common sense, given the particular nature of the accounts, that they should not be operated in the manner that they were.
But my question, just to follow up my question, so you're saying, because we're talking about adopting this tort here, so assuming assuming we confirm the torts adopted here, you want us to also validate you also want us to say that while scienter is obviously required to commit a fraud, you can aid and abet that fraud with no scienter.
It's not no scienter, Your Honor. I think we all agree actual knowledge would satisfy that standard. Something less than that, constructive knowledge, that's what the Superior Court said could satisfy.
Well,
And you agree with that?
They said should have known,
Should have known.
That's right.
which is different from constructive knowledge.
That's classic negligence.
That's a fair point, Your Honor. And so, for example, when we're assessing whether a plaintiff is aware that a claim is accrued for the purpose of a statute of limitations, we're looking at a very similar analysis. Did the plaintiff have actual awareness of the claim, or is the sum total of the circumstances sufficient to suggest that the plaintiff should have known? So this is...
Not should have known. You keep saying should have known. I mean, did know.
Did know.
Because you're talking about the difference between evidence to support knowledge versus what knowledge is. I mean, at the end of the day, I mean, in my view, the Superior Court's formulation brings in negligence, which has nothing to do with the way the restatement is written. It talks about knowing.
Or that standard in between negligence and knowing, which is more of a recklessness.
Well, that's exactly right, Justice Todd. It's unclear from the restatement. They simply used the word knowledge, what level of culpability they were talking about. We know that the Superior Court said,
I respectfully, sir.
Yeah.
Actually, I had a question when Justice Weck sort of jumped in front of me, which was fine.
Yeah.
He didn't know it. So I want to go back for one more second to the actual adoption, 876. Then I'll bring you back to knew or should have known, and we'll wrap this up. I thought he did answer.
No, he didn't answer.
All right, go ahead and answer. What was the question?
Well, it was
me.
Justice Donahue's question, over which I followed up, and then he was beginning to answer
it was
about the standard.
Yeah, I thought it was knew or should have known.
No, he
Do you remember where you were?
I do.
Would you answer Justice Todd for me?
Yeah,
And then,
so
and
the
then
court-
pause so I can ask you something?
Sure.
Sorry, Chief.
So the courts, the Ronick, the Bucci case, have used different phrasing to discuss the knowledge standard. Constructive notice, intentional ignorance, willful blindness, conscious disregard, reckless disregard. So these are not my formulations of the test. These are various other courts trying to say, essentially, a knew or should have known standard, or a head-in-the-sand defense will not suffice.
It's a spectrum.
Yes.
So where are we, if we're on that spectrum?
So the Superior Court's adoption is somewhere below actual knowledge and somewhere above negligence.
I'm kind of with Justice Donahue on this, though. I don't think should have known is anything other than a negligence standard, where you have to bring in basically an expert witness that basically says, I'm an expert in financial institutions, and if all of these facts were in front of me, I would have known this was fraud, even though they didn't know, and that's all you have to prove. It seems to me that the restatement is clear. It requires knowledge. I think, to your point that you were reading, you had me until you went to should have known. Actual knowledge can be established in multiple different ways, and it can be established through circumstantial evidence. It can be established by proving that someone knew something and they just stuck their head in the ground. That's still knowledge. But where I think the Superior Court may have gotten off track here is, and maybe they did it unintentionally, but they clearly said should have known. And that may be where I have the problem with the standard, just the articulation of it.
Sure.
Why don't
But
you tell us what the standard should be? I think that's what Justice Todd wants to know.
understood.
Well, and I also want to know I incidentally agree with Justice Brobson and Justice Donahue that should have known just sounds like garden variety negligence to me. But when you're talking about actual knowledge, in addition to telling us what you think the standard should be, could you tell us whether, in your view, actual knowledge means only actual knowledge, I saw him commit fraud, or does actual knowledge encompass the recklessness that is so reckless that it should be equated to actual knowledge.
Sure. Let me start.
Does that
with
make
this-
sense?
Yeah,
Do you understand?
I believe I followed you, Justice Todd. Let me start with the second question first. Actual knowledge is not limited to direct evidence of actual knowledge. The smoking gun, document, or witness where there's an admission, that so rarely happens. So we look at and courts approve the review of circumstantial evidence to discern whether Bryn Mawr, for example, in this case, had actual knowledge. And those things I mentioned previously was the risk obvious? Did the defendant have a particular training or expertise? Did the defendant have procedures designed to address that harm? If the answer to all of those questions is yes, it's certainly a jury question as to actual knowledge if that's the standard. And actual knowledge would be a high standard. If the restatement authors wanted it to be actual knowledge, I suppose they could have inserted the word actual. They used a more amorphous term, knowledge, which is what we're all struggling with here now.
It really doesn't sound especially amorphous for them to say no. I mean, they said that subject to liability if the bank knows that the other conduct constitutes a breach of duty. So I'm not sure what's amorphous about knows. They could say actually knows. They said knows, and we're not kidding. So,
You really mean it?
yeah.
Right.
May I ask you? I want to take you back again.
Yeah.
I got waylaid. We went forward, and I'm going to take you back and bring it forward.
Sure.
Would you respond to the idea that in this peculiar case we do more harm than good adopting 876B because we have the Uniform Fiduciaries Act? That was your opponent's argument, that it's the same cause of action for the same damages, and all we do is sort of make a mess of jury instructions if we have both.
Well, while there may be some overlap, the Uniform Fiduciaries Act requires a fiduciary. There are certainly many other circumstances where one can aid and abet a fraud not involving a fiduciary breach. So the Uniform Fiduciaries Act necessarily involves the involvement of a fiduciary. And on retrial, Bryn Mawr Trust may say, you know what, Bentley and his custodians were Bentley and his entities were custodians, not fiduciaries. Therefore, the UFA doesn't apply. So it provides a more general cause of action. And Justice Baer, it was tailor-made for this case. We have Bentley admitting his fraud, sentenced to 55 months in federal prison for operating a Ponzi scheme. The only way he could have operated this particular Ponzi scheme was with a bank, and a bank that looked the other way. So we have Bryn Mawr Bank being the instrumentality of the fraud that necessarily aided and abetted the fraud conducted by Mr. Bentley. So we believe that was our most on-point claim, and it was improperly dismissed before trial.
Let me bring you back.
Yeah.
That's a fine answer. Bring you back then to what no means. Again, we're not kidding. I don't know how big or small Bryn Mawr Bank is, respectfully. I come from Pittsburgh and just don't know that bank. I know how big Bank of America is. I know how big PNC Bank is, Mellon Bank is. And so it seems to me that it may be commercially unreasonable. Well, everybody here seems to agree that should have known negligence standard is just not feasible for these mega banks where the individual doing the Ponzi scheme is one of 1,000 millionaire depository or billionaire depository or the like. If we adopt we adopt what 876B says, that the other's conduct constitutes a breach of duty. Everything you're arguing is merely a question of proof, isn't it? We don't care how you prove it. Prove it through circumstantial evidence, prove it through inference, prove it any way you want. But the jury question is, did, in this case, Bryn Mawr, Mellon, Bank of America, know that the other's conduct constituted a breach of duty, giving substantial assistance or encouragement?
Right, right. So to put a very fine point on it, if this court confirms the existence of the claim and it agrees that we've stated a prima facie claim, it's ultimately a jury question whether Bryn Mawr Bank had knowledge.
Yeah, but the jury has to be, I know, just circling here, but the jury has to be instructed. Again, this is why we keep asking you about scienter, because...
Yeah, would you be nice enough to answer my question, and then I'll yield to Justice Wecht?
Sure. So it is ultimately a jury question once the prima facie claim has been made. So the court shouldn't have dismissed the claim on summary judgment, should have allowed it to go to the jury, who would consider and weigh knowledge, whether direct or circumstantial.
Thank you. Justice Wecht.
Justice Wecht, your question about no, there's one thing we haven't talked about, which I think is a very important piece of the knowledge puzzle. Bryn Mawr Bank had a duty to know its customer. This was not a duty that was created by Mr. Marion as the federal receiver. They were required by federal law to know their customer, and they had a written know your customer policy. That is found in the record at 1993A, and you don't need to rely on the parties' characterizations of the document. Looking at the document itself, what Bryn Mawr expected of itself must be aware of any out of the ordinary or suspicious activity that is not in keeping with the known and usual customer activity. As to monitoring, ongoing monitoring will consist of periodic review of account activity to determine any unusual transactions that may indicate possible money laundering activity or deposit account fraud. So this is Bryn Mawr saying to the world, we have a duty to know our customer. Here is our written policy. We're simply asking Bryn Mawr Bank to follow its own policy.
Well, but when you talk about duty like that, you're treading into negligence territory very quickly. And I get, and also you're arguing the evidence in front of an appellate court, which usually isn't a good thing to do. But I'll say this: when you go back, basically, I think your answer to the question is, you want the totality of circumstances test to be able to prove knowledge. That because you can't have the smoking gun, but you can show enough facts that a jury could conclude that that they had knowledge, constructive or actual, not should have known, but had knowledge, constructive or actual, based on the totality of the circumstances, which I'm assuming would include the stipulated fact that the fraud was concealed from the bank. Efforts were made to conceal the fraud from the bank.
So the totality of circumstances test, I think that would be an acceptable test because it would allow the court, the jury to evaluate all the evidence and give that decision to the jury. As to the stipulated fraud, I want to be clear on this point. While the party stipulated that Bentley attempted to conceal his fraud and did everything he could to conceal his fraud, what we didn't stipulate to is that Bryn Mawr Bank didn't otherwise have a duty to discover.
That's a problem. When you go to duty, you're going to lose.
But
counsel, I think that we're way ahead of where we need to be. If we conclude that that we adopt the tort, and then we conclude some quantum of culpability, either you knew or you really knew or you had to really know, and we send this back, then it goes through the normal trial course. If the judge non-suits you, you'll be back. If the judge grants or denies your suggested points for jury charge, or the other side's suggested points for jury charge, or if our suggested jury charge people who are not the court suggest some jury charges, that'll get argued and it'll come back, and that's the way the common law works. So I don't think we have to ferret out all of this now. What you want from us is a tort and a standard.
That's
the rest of it you'll argue below.
That's right, Your Honor. To be part of the retrial that includes negligence and the UFA claim.
And you do think you get a new trial notwithstanding we'll have to read the transcript and see what was said below.
Sure, sure. And that new trial will not include, we know from the court's limited grant of aliquotter, the improper evidence about the attorney's fees or the CD redemption strategy. We'll have a cleaner look, God willing, on retrial. But you're right, Your Honor, and I believe this court has gotten to the nub of the issue. And so for those reasons, we would respectfully request that the court confirm the existence of the cause of action, clarify that the Superior Court's adoption of the knowledge standard is correct, or otherwise fashion its own standard so that we know what it will be going forward. Thank you.
Thank you.
Thank you.
We are going to hear the last case before we conclude. Appellant and the co-defendant were tried jointly for the murder of appellant's son. During the trial, over appellant's objection, the trial court permitted the co-defendant's redacted confession to be read to the jury, despite the fact that the co-defendant did not testify at trial, implicating the Sixth Amendment. We granted allowance of appeal to consider appellant's claim that the trial court's ruling permitting the co-defendant's redacted statement to come into evidence violated the United States Supreme Court's decision in Bruton versus the United States. Please proceed.
Good afternoon. If it pleases the court, Mr. Chief Justice, fellow justices, my name is James Brownelli on behalf of Lisa Smith. The case before the court is really where the only issue at trial was whether this was third-degree murder and first-degree murder. And in that context, every fact mattered. And I think it's in that context that the court needs to weigh what was a very clear violation of the rule articulated by this honorable court in Commonwealth versus Johnson, that a co-defendant's confession must not contain a trace or hint of participation in the crime by the defendant, as well as a violation of the rule articulated by the United States Supreme Court in Gravy, Maryland, and this court in Commonwealth versus Travers, that preclude redactions that obviously implicate the defendant, even if the confession were the first item introduced at trial. Here, Mr. King, the co-defendant's statement explicitly names my client, Lisa, 9 times during the course of this statement. When a pronoun is used, it's only after her name had been named nearly 8 times at that point, but it's a gendered pronoun, she, and moreover, the statement, not from other evidence introduced at trial, the body of the co-defendant's statement as well, basically precludes the other female occupant of the house from any participation in the crime, indicates that grandma was upstairs doing her rehab when all this happened. It not only explicitly names her, but it also implicates her in the crime as opposed to leaving no trace of any sort of criminality.
Counsel, I apologize, but let me jump to the chase. Let's assume that we accept your position as correct. How does that outweigh or how does that cause us to consider or weigh that against your own client's admission regarding culpability such that it's just not harmless error?
I would argue it's not harmless for 2 reasons, Your Honor. First, while my client admits to 6 blows, obviously one of the real questions at trial was attributing the co-defendant's conduct to her in terms of who actually felled so many blows on the child's buttocks that led, of course, to the injuries that resulted in the child going into shock. In addition, the statement introduces a fact that's contained nowhere in the record, which I think it bears very strongly on what I was just mentioning, the co-defendant's statement. What the co-defendant's statement indicates is he was on his way to Aldi when he receives a phone call from my client. He then is placed on the phone with the young man, tells him if you'd have listened, you'd have been off punishment.
He wasn't a young man. He was a 4-year-old child.
I'm sorry, but 4-year-old child. Fair enough, Madam Justice. In any event, he returns home after having that conversation with the 4-year-old child, upon which literally within minutes, the child goes in the bathroom, removes his underwear, quote, knowing it was butt-whooping time, and then the beating that Mr. King admits to follows that. I think it would be a very fair inference on the part of the jury.
Counsel, I'm sorry. Counsel, here.
Yes, I'm sorry, Mr. Chairman.
Do you agree that Bruton says that the redacted statement has to directly and powerfully implicate your client, and then goes on to say that if the statement contextually implicates your client, it's permissible? So you have directly and powerfully implicates him in the crime, in the murder, not in living in this house or having a relationship with the other defendant, but directly and powerfully implicates in the crime rather than contextually implicates him as involved. Is that the legal criteria that Bruton sets out?
That is the standard. And contextual implication obviously goes to the identity of the person when you have, say, the other person, filled in terms of redactions. Here, my client's explicitly named. Moreover, for what I mentioned earlier, it does implicate her in the crime. It attributes, it says the slipper that she had been using, again, which goes to the blows felled by her, but then moreover discusses this phone call.
I'm not going to argue the case for the other side, but she could have been using that slipper to walk on. I mean, respectfully, and I take Bruton seriously, and we just decided a Bruton case where I think we may have been unanimous.
We haven't.
Oh, that hasn't come out yet?
It hasn't been written yet.
Yeah, I apologize. I get confused with that. We have another Bruton case under consideration. But your argument, I think, is that no redacted statement ever comes in if it implicates that the co-defendant knew the defendant.
No, not at all. What needs to be happening with redaction, as Johnson articulates, and the standard it sets forth, is you need to eliminate any trace of the defendant's participation in the crime. And here, I respectfully.
Is the best you got that he used the slipper, or is there something more?
No, is that she used the slipper, but then moreover, that she also made the call that precipitated the beating by the co-defendant. And I think that's a very important fact, because it's mentioned nowhere in the record. Perhaps it harkens back to my childhood. If mom called dad, you're in big trouble. But I think that's exactly the dynamic that you had here, and I think a jury could have reasonably found. That, in other words, my client, the second beating, the post-Aldi beating, if you will, by the co-defendant was precipitated and was done at the behest of the phone call made by my client. And that's an important point because the phone call does not occur anywhere else in the record. In addition, if you look subsequently at how the statement, the co-defendant's statement, was used later in the trial, I think it clearly is prejudicial. What the prosecutor did in closing argument was say Ms. Smith admits to 6 strikes, and then referred to Mr. King, the co-defendant's statement, and says, well, he admits to 7, that's at least 13, and basically invited the jury to take Mr. King's statement and use it to discredit my client's statement, which I think is, again, a very important point because the prosecutor here had to tie my client with the co-defendant's beating in order to, one, make her a co-conspirator with respect to that beating, and also to prove specific intent to kill.
Counsel, technically, that would be a gross misconduct allegation, not a brutal violation.
It would be a gross misconduct allegation, but certainly it goes in terms of your question regarding harmless error. Obviously, if you are to find that there was a brutal violation here, and I think there is one indeed, it needs to then be weighed and examined in the context of the entire record. Is it harmless or not? And in terms of how the statement was subsequently used or played out at trial, I think it absolutely is something for the court to examine in terms of whether my client's prejudiced by it.
Thank you.
Do you have anything you'd like to say in conclusion?
Just, Your Honor, I think if you look at the statement itself, it again implicates my client in terms of use of the slipper. It implicates her in the phone call that precipitates the co-defendant's beating. For that reason, literally if it were the only piece of evidence at trial, this could have been enough to convict my client without anything else.
We'll have to read the trial transcript,
Certainly.
and we will certainly do that. It's a serious case.
Justice Montemuro, my old boss's favorite saying was, "Blessed are the brief," so with that, I will yield to my learned colleague. Thank you.
Thank you very much.
Sir.
And how do you pronounce your last name? Chappie. Chappie, go ahead.
Good morning, Your Honors. Adrienne Jappy on behalf of the Montgomery County District Attorney's Office. This case doesn't present a typical Bruton situation where a non-testifying co-defendant statement is redacted to delete all references to the defendant and replace them with neutral terms and phrases. Lisa Smith's name does in fact remain in the statement, and this was after we went to great lengths to redact all references to her in the statement that identified her as a perpetrator to the crimes against Tajir. All that remained in the statement in terms of Lisa Smith and her name were references that rendered her unidentifiable as a perpetrator in this case. In fact, we essentially de-identified her as a perpetrator. We left in their background information. She was Tajir's mother, how we had to keep that background stuff in there to show how the co-defendant, Mr. Keefe, came into contact with Tajir.
Well, I suppose you could have used other words other than she. You could have said the other person or something like that.
Well, not necessarily in this case, Your Honor. We don't have a situation here of several defendants engaged in a robbery. This is a child being beaten, abused, tortured, and killed by the mother and the other caretaker. So it was kind of hard to do that, and we needed to maintain the integrity of the conviction. So we took out a couple dozen instances in which Mr. Keefe alleged that she was partaking in this abuse of Tajir, and we just left in, for the most part, innocuous references. Like Lisa was feeding the kids, Lisa was tending to my grandmother, was giving her medicine, and things of that nature. And the mere fact that the statement identifies someone who a defendant doesn't identify as a perpetrator does not make this a Bruton violation.
Who else could it have been in this particular context? This particular case, given that the great-grandmother, the 90-year-old great-grandmother had been excluded by the other part of the statement, who else could the she possibly have been?
And that's something I want to clarify, because my understanding of the defense's brief and his argument here today is that we redacted the statement to change Lisa's name to she to kind of imply it was someone else, not her. We did not redact any we did not change her name to she at all, because this isn't a situation where she is referencing criminal conduct. The she was used in the context of she gave my grandmother medicine, she fed the children, she called me. That's innocuous conduct. That's not any criminal conduct, so that doesn't have to be redacted. And we did not redact Lisa's name to make it she.
No, I'm not suggesting that. I guess what I meant to ask you, counsel, is given the context in which this was presented to the jury, who else could the jury possibly have surmised it was?
No one, Your Honor. It's our understanding. We wanted it was Lisa Smith. We left it in there so the jury knew that Lisa Smith was the other person at the house. Lisa Smith was Tajir's mother, but we only took out the statements about her that referenced her as a perpetrator in the crime. We didn't care. It's not a violation of one's Sixth Amendment rights if someone stays in this, someone's name remains in the statement, whether it's Lisa.
I didn't want to interfere with your final statement, but my question would be, I understand that, and that's well articulated, but the fact remains that if that statement powerfully and directly implicates the person, it's not acceptable. And you've just shared with us that the concept behind the Commonwealth's moving the statement in of the co-defendant was because it powerfully and directly implicated her. So the question becomes one of why should it not be stricken just for a violation of Bruton?
Because Bruton is only violated when the statements powerfully incriminate, expressly incriminate, or facially incriminate the defendant. We took out all the statements regarding she and Lisa Smith that incriminated her in any crimes against Tajir.
But you left her in with regard to the non-criminal conduct involving the same parties who were seated at the defense table.
Correct, Your Honor.
Clear that she was the only other person there. That's
Correct, Your Honors. But there's no implication in Keith King's statement as redacted that anyone other than the defendant or other than the co-defendant, Keith King, committed these crimes. There's no indication that Lisa Smith or she engaged in any of this criminal conduct.
What about the statement, I used my open hand like 2 or 3 times, then I used a slipper that she had been using, and I used that to hit his butt 3 or 4 times, so like 5 or 6 times altogether, that she had been using?
Your Honor, that's not an express implication of criminal conduct. The only way that becomes incriminating is when you look at it in the context of the other evidence at trial, most notably Lisa Smith's own statement where she expressly states in no uncertain terms that she smacked Tajir with the flip-flop on the buttocks 6 to 7 times. As the statement stands, it doesn't say when she was using the flip-flop, how she was using the flip-flop, if she was even using it on Tajir. And for all we know, she was, when he said using the flip-flop, he meant she was wearing the flip-flop. So we don't know. That doesn't directly and powerfully incriminate her. And that's the language.
Ms. Jaffe, just let's take a step back here. You have, in this case, a confession by this appellant that is, in all likelihood, in my view, going to render any of this harmless error. But what we're focusing on right now is, was there a Bruton violation? And I shouldn't speak for my colleagues, but I would view, I think there's a strong likelihood of harmless error if there was error. But we really need to focus on this use of her, the references to her in the statement and the she. And, you know, we're not getting into jury arguments here. We're just discussing this as a matter of law, whether this the references to her were proper under Bruton. So if we could just kind of focus on that without actual argument about it, what we're trying to figure out is the context in which she was placed and the references to her, whether they violated Bruton. So that's not getting into the fact that her confession already revealed a lot of this, and whether we get to the harmless error argument, but just that specific issue of Bruton. So could you just address that for a moment?
And in addressing that, it's important for me to set forth the language in the Bruton trilogy cases. So Bruton doesn't hold that any time a defendant is named in a statement, it's a violation of one's confrontation rights. Bruton states statements that, quote, powerfully incriminate or expressly incriminate or facially incriminate a defendant in criminal activity violates the Sixth Amendment. Now, Richardson, citing Bruton, says a defendant is deprived of his right to confront witnesses, and I quote, when his non-testifying co-defendant's confession naming him as a participant in the crime is introduced into evidence. And lastly, Your Honors, Gray, it describes Bruton as a rule prohibiting the introduction of a non-testifying co-defendant's statement that names the defendant, quote, as a perpetrator.
Counsel, can I follow? Oh, I'm sorry. Yes.
If you would finish your answer, yes.
And by that backdrop, if you look at the cases from this court, Brown, Travers, and other cases that cite to and discuss Bruton, they all cite to Bruton as, and I quote, directly and powerfully implicating the defendant in a crime. And in Travers, this court made clear that the Bruton violation was not just because the defendant was named in the statement, but that the defendant was named in an incriminating fashion in the statement. So all the references that remain in the statement in this case to Lisa Smith or she are not incriminating statements and only become so when viewed with other inculpatory evidence at trial. But that's not a Bruton violation because that's contextual implication, and Richardson versus Marsh expressly states that that cannot be a Bruton violation.
So let me follow up on that
Sure, Your
argument.
Honor.
So why should this court not take your argument into consideration, coupled by Bruton and its progeny, Richardson and Gray, and say, from here on out in Pennsylvania, if you intend to introduce a statement implicating your co-defendant, only those non-incriminating statements as she handled my mother are permitted, and any references are redacted with regard to any potential criminal activity. Isn't that consistent with Bruton and Richardson and Gray, such that you then argue through other admissible evidence attempting to link the non-incriminating statements to the co-defendant? In essence, instead of using she hit or she scolded, we just blacken it out, and that's not read to the jury. Why should we not follow that? Because I'm finding if we're going to follow your logic of the non-contextual statements, then I find it very plausible that from here on out, we could follow the cases, the direction of our own case law and jurisprudence and that of the Supremes, to say, hey, we will allow Bruton co-defendant statements to come in, but there'll be no more references to who the co-defendant is in any alleged criminal conduct. Therefore, in essence, we're redacting the entire sentence, not just the name of the perpetrator. Does that make sense to you?
Well, Your Honor, that's what we did in this case. We redacted dozens of sentences setting forth criminal conduct engaged in by Lisa Smith. But maybe I'm missing something here, or there's a disconnect, but we did in fact take out all references to criminal conduct, and what remained in there was all innocuous references. And there's no case law from either the United States Supreme Court or the state courts here that say you are not allowed to leave a defendant's name in a non-testifying co-defendant's statement if it's regarding innocuous conduct or activity.
We can after this case.
Sure, Your Honor, sure. And as a follow-up on your question, Your Honor, but I disagree with the premise of it in that we don't have any inculpatory language regarding she or Lisa Smith in there. But you ask, why don't we just come up with a rule to take all this stuff out? Because when we do redaction, we have to maintain the narrative integrity of the statements. And I know, Your Honor, Justice Kennedy at the last, Justice Doherty at the last session with this court, when there was a Bruton argument before the court, you questioned some of the attorneys about significant redactions and discussed, and questioned, well, isn't it manipulation, sometimes perversive manipulation, if you're just extracting so much stuff from the statement? So we have a fine line that we have to draw here. And we started with the premise, we just took out little by little what we needed to ensure that the defendant's Sixth Amendment rights were being remained intact. So we took out what we needed to, and we went to great lengths in this case to redact the statement, and then Judge Furman as well, she did some additional redactions. So
sometimes it just might not suffice, right?
Correct.
I mean, it's not a panacea. Sometimes it doesn't work and you have to sever them, right?
Correct. Sometimes we do have to sever it, but
Ms. Jappi, Justice Donohue has a question she wants to
Sure.
ask.
Sort of in follow-up to Justice Doherty's thought process, I believe. There are two statements in here that didn't have to be in this statement that was read to the jury that would have done, the statement would have still done its job as to King. The one involves that he used the slipper that she had used, and the second is the one that expressly ties her to the conspiracy, which is she made the phone call that precipitated the beating. Why did those statements have to be in there for the quote-unquote integrity of the statement?
well, it just, the one statement, the statement which she called me, and then when he came home, he administered the beating. There was, in that paragraph, in that response, there were several statements saying, she called me, she asked me to come home and beat Tajir. And we took out the stuff, the segments that said, she asked me to beat Tajir. We left it in because it doesn't show any incriminating conduct on her part. She's simply calling the defendant. And just to be clear, this wasn't the only beating. She didn't just call him and he came home and beat Tajir. Tajir was beaten to a bloody pulp and tortured all day.
This baby was mutilated. There's no question about that. It's a horrible circumstance, except we're dealing with a very technical legal issue here. And the point is, the suggestion that she made the call that precipitated the additional beating, that ties her to a conspiracy. And my understanding is what your opposing counsel's argument was, that's the only thing in this case that did that. And so to say, and then when I got home, I beat him again, would have gotten you where you needed to go with this. And I think that was Justice Doherty's point in part about this notion of sanitizing, but not quite enough to really get the co-defendant out of the picture.
Your Honor, if I'm not mistaken, in Lisa Smith's statement, she does in fact mention that she called the co-defendant when he was out at Aldi. I'm not 100% sure of that, but I believe she in fact did. Regardless, that statement that she called him and then he later on came home and beat Tajir, he was out, he went out a couple times to Aldi, and when he would come home, he beat Tajir. So just because she called him, that doesn't necessarily mean she was part of the conspiracy. She was telling him to call him. So that's not a direct and powerful implication that is required in order for there to be a Bruton violation.
Counsel, on your notes of testimony, June 18, 2019, page 217, King stated, on my way to Aldi, she called me, She put me on speakerphone, and I was telling Tajir that he would have been off punishment if he had listened to his mom. How does that not powerfully and directly implicate her? She is the mom. That's the argument. That's what's here. I got it. Look, candidly, this was overkill. I believe that on a review of the record that was absolute substantial evidence that would have proven a conviction. But the introduction of this statement, we have to take it as it is. And you guys have to accept and argue why your district attorney insisted on such overkill that it brings you to the Supreme Court, is the first question I would have. The second question I have, how does the reference to the co-defendant or she as mom, how does that not powerfully and directly implicate a Bruton violation?
Because the only way it's implicating her, because at this point we don't know that she's involved in the crimes against Tajir or the conspiracy. The only way we learn that is through the other incriminating evidence of trial, most importantly, her own testimony. So on the face of the statement, while there might be an implication, there's no direct and powerful incrimination simply by that statement.
I apologize. But when you take that when you take it in context with page 218, 219, where he says, I then used a slipper that she had been using, and I used it to hit his butt 3 or 4 times, so like 5 or 6 times altogether. When you're taking it in the aggregate, it's obvious that this is directly and powerfully addressing who the co-defendant is and the defendant. You're failing. In isolation, your argument holds water. Share with me, because you're ably to argue this, share with me how I'm not to take it in the aggregate to understand just by those comments alone, not any additional evidence?
Because based on the face of the statement itself, there's no direct implication of criminal conduct. It's only when you look at her statement, wherein she says she used the sandal or the flip-flop to strike Tajir 6 or 7 times, then you realize that she did in fact partake in this criminal activity. And Richardson says that's not a brutal violation. And in terms of the phone call, I lost my train.
Well, Ms. Jaffe, let me follow up on Justice Dougherty, and if I don't satisfy Justice Dougherty or Justice Weck, I'll have more. But you raise a really interesting point of law, and I frankly don't know the answer, and we'll have to go find out. That's why good law clerks are sitting behind you. Well, let's do this concretely. The statement that he used her slipper, in and of itself, not a brutal violation. But if the trial transcript indicates that she beat the child with her slipper or her flip-flop, I'm assuming that slipper and flip-flop means the same thing.
It does indicate that.
Okay, so she beat the child with the slipper. Then you put in the statement from the guy, the co-defendant, that he used her slipper. It seems to me that in the real world of context from the record, that it's pretty easy for the jury to appreciate that the slipper she beat the child with is the slipper that he used. And so in context, you may have a brutal violation if you use context, contextual implication, if you will. And are you saying you don't do that? You look at this statement in isolation, or to make myself clear,
Yes,
do you
Your
look
Honor.
at this statement as part of a total record?
Yes, Your Honor. You don't look at the statement in terms of the other evidence of guilt. And I think you said if you look at it in the context of the record, then you clearly have a brutal violation. And you don't have a brutal violation because Richardson specifically says if the only way you can determine that this part in the statement where it says he's using the or he's hitting him with the flip-flop that she gave me, if the only way you can implicate she in that statement as using...
He used the statement that she had been using. That was the language.
Yes, if you apply it with the record, her incriminating statement where she said she used the flip-flop to hit him. But Richardson expressly says you're not allowed to do that.
All right, thank you. Justice
May I,
Fleck?
yeah, in response to Justice Dougherty a moment ago, you appeared to minimize the use of the statement in favor of invoking her own statement. Isn't this belied by the fact that the prosecutor used the statement in driving home the point in closing argument to the jury? Didn't the prosecutor emphasize this, underscoring the brutal violation?
Your Honor, I addressed...
Because sorry to interrupt you, just what I'm trying to say is, if it was correct, as you said to Justice Dougherty, or as I heard you to say, that the statement wasn't so much after all, then why was it so much the focus of the prosecutor's closing argument?
Your Honor, it wasn't so much the focus of the closing argument. In the first assistant's closing argument, he was talking about the strikes, the flip-flop, that co-defendant Keith struck Tajir 3 or 4 times, so he said, and with the flip-flop, and then another 2 to 3 times with the hand. And then the prosecutor stated, the defendant in this case, Lisa Smith, struck him 6 to 7 times. And each time the prosecutor talked about the statements, the prosecutor talked about the individual statements, did not conflate them together or anything of that nature. The prosecutor was simply talking about the severe nature of the injuries and was saying both of these 2 defendants are probably not telling the truth because the testimony from the forensic pathologist says he was beaten with a flip-flop or beaten with something on his buttocks so many times that the tissue became pulpified and toxins leaked throughout his body. So he was basically arguing, so they're saying they hit him 5 or 6 times each? That's not true. The pathologist said he was hit dozens of times. That was the context in which that was brought up. There was no conflating of the statements. There was no saying that because saying that Keith King said Lisa Smith struck him with a statement. The prosecutor went through each defendant's statement and said which each defendant did.
Counsel, I want to follow up on a point that Justice Donahue made earlier, and I'm wondering, does it make sense to avoid all these Bruton cases, to have a standard that says all statements implicating a co-defendant that are not necessary to maintain the narrative integrity of the confession must be redacted?
I suppose that could be a starting point. However, I would suggest it should be a case-by-case basis, and it depends on the nature of the circumstances in this case. And even this case, we felt that it was necessary to keep Lisa Smith in there in the beginning of the statement to show the relationship between the parties and that Tajir was a dependent of both of them. But then I guess sometimes it's a gray area. Is a certain statement needed? Is it not? I think that would just end up in additional litigation. But perhaps that rule can be segued into a case-by-case basis rule based on the circumstances, the nature and circumstances of the various cases, because it's sometimes difficult to tell at the outset prior to trial whether or not something is innocuous enough to not be incriminating in nature. And
No, I'm not talking about, I understand, I appreciate your answer. I was going toward more, instead of that a question, is it innocuous enough that we can keep it in? Should we adopt a standard that simply says, if it's not necessary for the narrative integrity, it should be out?
I don't know if that's necessary, because I don't think you have to look much further than the Bruton trilogy of cases, which expressly says if a statement expressly implicates or powerfully incriminates and words of that nature. So implicit in those rulings is that if you have the name of a defendant in a statement, but it doesn't powerfully incriminate her or powerfully identify him or her as a perpetrator of the crime, then I would submit, just based on those Supreme Court cases alone, then that would, implicit in that would be you could put in references that do not identify her as a participant as a crime.
Would it help at all? Does it make any sense to adopt a rule, and we're playing what if here, that said never use the co-defendant's name, always use the other person? Now, in this case, I suspect that everybody would understand that the other person is Mom, who lived with the other perpetrator and was the mother of the child. But it would sanitize it. It would nominally sanitize it.
Well, I don't
Particularly if you also added on, don't use the gender reference, don't use, I mean,
Yeah.
we have so many cases where the one we have under consideration now that we have not yet decided, it was my friend at the firehouse. There are uses that narrow the other person, that, you know, you can surmise who that other person is by the use of a more descriptive term, where the other person would seemingly always be safe.
I don't think that would be helpful in this case, because that would kind of be an artificial redaction, and in the United States Supreme Court in Gray, they basically said you can't use an artificial redaction. Even this court has said on occasion when they've used the other guy, for instance, in one case, Commonwealth versus Markman, the other guy was used, which generally is permissible, but the way it was read to the jury, it was dubbed through a video recording or an audio recording. And
But it's better than the redheaded guy with acne. You know?
Sure, yes. But in this case, it would be artificial because it's the paramour here. And obviously, he's talking about his wife or his girlfriend or fiancée or baby mama, whatever the terminology is. So that would be an artificial redaction to use the other guy. But there didn't need to be a redaction in this case, because for the stuff that was left in, because our position is everything that's in there is not incriminating, therefore we didn't need to do any redaction further.
Well, it's also been said that just deleting is not the way to go. I believe
Correct, if you just say delete it or leave a blank not line, because that again is an artificial
it's a
redaction.
sticky wicket. But you know what? We're going to work on it.
Yeah, I just have one quick question.
Sure, Your Honor.
Is your secondary argument that if this court were to find it that it's Bruton, that there's overwhelming, compelling evidence such that it's harmless error?
Yes, Your Honor.
Good answer.
And I set it forth in my brief in detail. I just want to point out, most notably, the defendant's own statement, wherein she sets forth in great detail the atrocity she committed on her son on the day of the murder.
Thank you.
Thank you, Your Honors.
Thank you very much. We'll stand in recess.
Tough facts.
Great argument.